My lords, if I can make one submission for listing one matter tomorrow. My lords, this matter, I am for the respondent father. This matter was referred to mediation by the mother. They didn't appear. Mediation has now failed. I have got a decree for custody of the child. She has taken the child, not returned the child, and filed a new suit in the family court saying that my marriage is not valid and so that decree should be set aside. Files a writ petition saying ex parte stay was not given against that ex parte refusal, and matter was sent to, I have filed a contempt. My child has not been returned from the summer vacation despite
Is there any order by this court?
No, but it was for mediation. Let the mediation be closed. This will be used, my lords. I have filed a contempt. This is now being used as if parties are settling. There is no question of settling. Let this matter be taken tomorrow. Great.
Lordship, there is a, I'm supposed to hand over the children on Saturday. Already in June, this court has taken cognizance that there were allegations that the father overnight stay was not granted. In spite of the orders and petition of this court, again we have gone back to square one where overnight stay has been given to the children. So I'm challenging that order.
When was the order passed?
Monday. On 19th it was passed, the order.
Yes.
Tomorrow.
Is it being mentioned? This is item 17.
No, it's not. I think.
All these matters, if office objections are complied, then only list this matters. Yes. All the list.
On submission, my lord. On 1980, lordship, the passed an interim order. Husband has filed a petition. At that point of time, the wife has filed a petition. He stated that also club along with the club. The lordship has passed an order. Once it is a WP's number, it can be put up at the lordship has passed an order. See, because that is number has been made because there is an interim order. So once it is numbered, the lordship, the matter is an urgency.
Whether it is numbered or not.
It is in the first stage they have moved it, my lord. At the if they move, the lordship has passed an order.
Whatever it is.
One submission, my lords. My lords, this is RPFC 176/2024. Last time on 16/9, it was listed in the in chambers, my lords. Because the husband didn't show up, my lords told that it has to be listed today before the regular bench. It hasn't come, my lords. Though it's showing on the case status, it has to be listed.
RPFC of 2024. What is the urgency at the fag end of the?
No, my lords. The thing is, interim order has been granted to the husband saying that any no coercive steps has to be taken. Since that, he's not paying any.
Only a matter of a week or 10 days. After that, it will come after vacation. It will not take. Already there are so many matters tomorrow. Yes.
Page number 1, list number 1, page wise adjournment, page number 3, serial number 7, page number 4, 8 to
My
6.
lord, serial number 7, my lord, for the petitioners, my lord. Currently, there's an order for stay by the Supreme Court, and the case is still running before the Supreme Court, my lord. So we have not received the certified copy, my lord. Hence, we could not submit.
It is 7. Please wait. Let other side be here. Next.
Much
Page number
obliged,
4, serial number 8 to 16.
Serial number 10, my lord. Lordship can record next week.
Fresh matter.
Fresh matter.
Why are you asking for time?
Some my inconvenience today, my lord. Today.
It will reach in 10 minutes. Yes.
Page number 5, serial number 17 to 26.
22, your lordship.
Yes.
For respondent counsel, I have informed the other side. Other side is also present.
Appearing to the petitioner, may request for the matter to be taken up
After vacation.
The matter is posted for cross-examination of the respondent. They are pressing for cross.
I can't assure you when it will come after vacation. I can only say after vacation. Because we can't fix next bench's roster by giving so many dates. Yes.
After vacation. Page number 6, serial number 27 to 30.
Serial number 27, your lordship. We are for the respondent. Written objections are ready, your lordship. Today we will file. Kindly short accommodation.
Have you informed the petitioner counsel?
Yes, kindly, your lordship.
Huh?
We have messaged him. Morning, we have messaged him, your lordship.
It is at the request of the unconscious respondent.
27.
It is submitted that they have already informed to the petitioner. List this matter after vacation.
List number 2. Page number 2. Serial number 4 to 7. Page number 3. 8 to 11. Page number 4. 12 to 17.
List number 2.
List 2.
Serial number 11.
Serial number 11. Serial number 11, my lord.
Serial number 11, I appeared for the petitioner. Only yesterday, my learned friend has given me a copy of the application saying he is an appraiser without furnishing me annexes A, B, and C. Therefore, I have requested my learned
We'll
friend.
give you.
Furnishing, my lords.
We are furnishing. Post it.
This is not after vacation.
One. Since from 3 times you took, matter is not reached. Last occasion and the matter is reached, my lord. Now once again he is taking the time. madam.
Adjournment
The
is-
matter
would
is
not
pertaining to
only
the wife, my lord.
For appearing who are all the three?
Appraiser.
All the three,
Appraisal.
three advocates will argue for the
Give me
respondent.
the copies.
Whoever is,
One.
yes. This is matter after vacation.
Kodi copies.
Page number 4, serial number 12 to serial number 17. Page number 5, serial number 18 to 20. Page number
Your
9.
Ladyship, serial number 20, I seek for an adjournment, Your Ladyship. We have informed the other side.
Yes, after vacation.
Obliged.
Yes,
List number 3, page number 2, serial number 6.
Serial
page
number 4, my lord. Serial number 4, I have kindly adjournment, my lord. I already informed to the other side, my lord. Respond number 3.
yes, this is in the month of December. Office, non-compliance of office objections
Yes, ma'am.
shall be complied with by 14th of October or else default order.
My lord, this serial
Page
number
number-
8, my lord.
Serial number,
8.
Page number 3, serial number 7. Page number 4, serial number 8 to 11.
8, my
This
lord. I need
yes.
the time as I had to file additional documents, my lord.
Have you informed the other side?
HR Renuka.
No, my lord.
Wait, yes, next.
Page number 5, serial number 12 to serial number 14. Page number 6, 14, serial number 7. Page number 7, serial number 16 to 18.
Serial number 16, my lord. I got some personal inconvenience. I have informed the other side, B. Pradeep
After
and
vacation.
Tipeshwar,
Yes, next.
after vacation.
Yes.
Page number
Serial
8,
number 15 minutes.
15.
15. I appear for appellant minutes. Praise for time.
Have you informed the other side?
Other side.
Yes, after vacation.
Page number 8, serial number 19 to 21. Page number 9, 22 to 25.
Number 22. 22 withdraw as not.
Serial number?
22 minus. List number 3.
ಏನಿದು?
Remove his file seeking to withdraw the petition. Dismissed as withdrawn. Claimant or owner?
Claimant.
List
Yes.
number 2.
Page number 10, serial number 26 to 28. Serial number, page number 11, serial number 29.
My lord, serial number 29, my lords. I am for respondent number 1. Appellant counsel's brother has expired yesterday, my lords. So kindly after have it on the
Matter after vacation at the
grateful,
request
my
of
lords.
then counsel to the appellant. Yes.
List number 4 for referring to local adalat. Serial number 1, that is furnishing of process for R2.
When Mr. Vijay Kumar is taking notice, why to issue notice to R2?
ಅದು file ತಗೋ. Referring to local adalat, serial number 1. 1.
As Mr. D. Vijay Kumar has not filed his wakalat, this court had directed you issue notice to the respondents again. Delete the name of Mr. D. Vijay Kumar. Mr. P. Pradeep is directed to take notice and shall file the wakalat by the next date of hearing. Put in the name of Pradeep. Yes, next. All other matters to local
Refer to
adalat.
only one.
Yes.
One submission, my lord. List number 2, serial number 2, my lord. Matter is settled between the parties before mediation, but it has to be reported before the family court. That amount has to be paid in the family court.
and it has to be recorded in.
Third of my lord, next.
RPFC is pending here.
That's what, my lord. That amount, he has to pay the amount. He has to get the DD, that
That I
respondent.
understand.
Hmm.
RPFC is referred to the mediation. You have settled it in a pending RPFC. Why should it be reported before the
He is not paid the amount before this honorable court. He is ready to pay the amount before the family court when
In divorce petition.
in divorce petition
divorce petition is pending there?
filed, my lord.
The date
Hence,
was fixed.
for
in
some
the
time,
third
may,
of October.
sometime it may be urgent, my lord.
When we called
Still
after
pending
vacation.
disposal of that.
Application.
Please,
Number 2 is next.
great.
List number 1 for dismissal, serial number 1, Manjunath. Members of petition, appellant, petitioner, Basavanna.
Yes.
A petition filed seeking challenging the entry maintenance of passed by the
Where is, which page number?
page number, my lord.
Page number 13, please.
30?
13 onwards.
Where is it, your order?
The page number 13 onwards, please.
Page number 16, my lord. Order starts from page number 12 to
Court has granted
question of
10,000.
the page number 16, my lord.
What is your salary?
He is not working, my lord. He is having a own provision store as per
What is
except
the income out of that?
only 40,000 per month.
You are for the wife or husband?
Husband, petitioner is husband.
So you're working?
No, he's
Your income
having
is 40,000.
provision store, running provision
I
store.
understand your income is 40,000.
40,000.
Court has granted 10,000. What is wrong with it?
No, my lord. 45,000, 10,000 each, my lord. It equals to 30. There are 2 children. 10,000 each, my lord, including wife, plus 15,000 rent. Also 50,000 rupees per.
Please come to the discussion. On what basis all this is done?
They have filed the petition, my lord.
Come to page 14, paragraph number 2 and read.
Please. It is also noted the dispute that respondent is self-employed and the petitioner has claimed interim maintenance of rupees 75,000 towards the maintenance of herself and towards her children. But the respondent stated in a statement that he is providing for education and to a children and spent for 14 lakh towards the education, but there is no supporting document along with statement.
Then how can you spend 14 lakhs towards?
My lord, first daughter is B grad student. He has provided all the education expense. Now she is 22 years old. Till date, he has provided all education, even his second daughter also. But they have stated in the year 2011 itself, she deserted the petitioner.
This order is passed when?
Please. Its order passed on, my lord. 7/11/2023, my lord.
7/11?
2023, my lord.
What was her age by then?
Then, my lord, as per the order of this honorable court, he has paid 7 lakh rupees to the respondent.
The age of that daughter as on the date of this order?
Yes, on the date of
24
order, my
years.
lord. First daughter is
23 years.
23 years.
As on that day?
As on that day. The first daughter is 23 years. She was
Then
pursuing.
how is she entitled?
She was studying in B, please, my lord.
How is she entitled?
The education expenses and until she get married, she's entitled, my lord, and she has no source of income. She's continuing her education. And the petition was filed in the
CRPC,
the,
what are all
the
these
petition was filed in the year 2021. They are separated in the year 2011. 2011 to till 2000. In the 2016, there was a settlement between the parties. He has taken all the respondent and the family members, and again he has sent back. And there are some disputes, and earlier petitions were filed.
The court not supposed to ascertain what is his income? What is his
No, the
maintenance?
thing is,
10,000 each is 30,000 and 1,500.
the impugn order, the continuation of the impugn order may kindly be seen, please, my lord, in the page number 40, the last para onwards. And he has stated in the second para, he said it's a 14 lakhs rupees has been paid for education expenses. Not even a single piece of document has been produced.
Forget.
And it's,
Forget about
please,
what
ma'am.
he said.
Please, ma'am.
No, you have come up before the court saying you want this much of maintenance. And he has filed his statement of assets and liabilities.
Assets and liability he has suppressed. I'll come to that point, please, my lord. And before that, I'll go to the impugn order passed by the trial court, the court below. In the last para in page number 14, please, my lord, the petitioner present and submitted that the respondent owns immovable property and also does own business and also own house property, and he is getting a rent from the property. They have also produced the fee paid receipt, please, my lord, and of the children's, and also produced the copy of the partition deed between the party respondent and his brothers. Therein the said document shows that page number 14, the respondent has acquired one house property in first floor at Dasaralli village, wherein the property bearing number so and so, measuring so and so. And therefore, looking into the status of the petitioner who is away from the respondent and paying this court to award maintenance in their basic necessities, and by considering all these aspects, the trial court has, the court below has come to the
Set aside this order
And-
and remand the matter back to the court. That's
No,
not the way
no,
the
they
court
have-
grants. What is the, because in a partition suit, if a person gets a house, that shows the financial status and court will grant.
He is getting a rent of more than 1,20,000 to 20,000
Where
rupees.
is the document for that?
Documents have produced the documents of the partition deed and the photographs also produced and also documents for
Where is this house situated?
Dasaralli, but in Bangalore itself, please. Madam.
Hmm.
In Bangalore itself, he is getting more than 1,20,000.
Like, if he's having all those assets and he's getting that much of amount.
Only-
Then you will be given more maintenance than this.
So
Let
we are
the court
unable to
decide.
get the rental documents and other things. And also addition to that, he's running a provision store and also having a bangle store, please, my lord. And it's only for avoiding he has not produced the bank statement before the trial, as per the
That's
assets
what
and
I'm
liabilities.
saying. Now all of you will produce everything before the court and court will decide.
Please,
Please,
madam.
please.
Please come.
Until such time, there is a due of more than
The interim
25.
order, what is the interim order by this court?
Interim order was awarded by this honorable court to pay 50% of the
50%.
amount, but as on the date of order, there was a due of 26 lakhs, my lord, and the submissions of my learned friend, so factually is not correct. He has stated it's 14 lakhs rupees.
Lord, I have already paid, they have received, they have acknowledged.
The 14
They
lakhs
produced the
rupees.
order sheet also.
So 14 lakhs rupees, but as on the date of the order,
For the
there was a
family
due
court, they
of
have received.
26 lakhs. And as on today, it's more than 35 lakhs, please, my lord. And
There shall be an interim order of stay as paid for, subject to the condition that petitioner would deposit 50% of the arrears amount, that is 7 lakhs,
Please.
within a period of 4 weeks. That's
Correct.
the order.
Correct, my lord. But the submission was made by this honorable court by my learned friend. It's a 14 lakhs is the arrears amount.
As-
14
as
lakhs,
per
but
our
as on the date
calculation,
of,
my lord.
as on the date of 2000 interim order, the arrears was 26 lakhs rupees. my lord.
No, we cannot count the arrears at this amount.
Correct.
It has to be, what the court has, it is 30,000 plus 15,000, that is 45,000. is what
45,000
granted.
plus education expenses.
Let him pay 20,000, at 20,000, whatever are the arrears, let him pay pending
Please,
consideration.
please.
The agreed with the order passed in I number 2 in criminal miscellaneous number 94 of 2020 dated 7/11/2023, whereby the court had granted maintenance of an amount of rupees 10,000 each for the 3 petitioners, but to the 3 respondents, and 15,000 towards rent, and also the educational expenses. The husband is before this court. Learned counsel appearing for the husband submits that the husband is running a provision store and is getting an income of 40 to 45,000. Now the court, by virtue of this order, had granted an amount of rupees 45,000 apart from educational expenses. It is submitted that court has failed to consider the financial status of the husband and without any basis has granted the amount. Next paragraph. Learned counsel appearing for the respondent wife submits that the court had rightly granted the amount. It is submitted that he is having, as per the partition in the partition suit, he got one house property, whereas it is fetching 1,25,000 per month as rent, and apart from that income, he is having a provision store, and from that also he is deriving income. All these, he has not, as per the judgment of the apex court in Rashish versus Neha, he has not filed the bank statement. He has not placed he has not placed before the court all the documents that are relevant to, relevant. It is submitted that when the matter came up for the preliminary hearing before this court, it is submitted before the court that his earning, the arrears are 14 lakhs, but in fact the arrears are 27 lakhs. And yes, and there was a direction by the court to pay 7 lakhs, and it is submitted that the 7 lakhs is paid. Next part. Having heard the counsels on either side, peruse the material on record. When the wife files an application seeking maintenance, and she has to say, the burden lies on her to prove that what is the income of the husband. And as per the judgment of the registrar Sneha, both the parties have to file their statement of assets and liabilities with the documents. From the material on record and from the submission, it appears that the parties have not complied with the same, and all the documents that are supposed to be filed, along with the statement of assets and liabilities, are not filed. But in spite of the same, the court had granted maintenance of an amount of rupees 45,000. This court is of the view that without any basis, court cannot grant maintenance of 45,000 along apart from the educational expenses. In that view of the matter, this court deems it appropriate to set aside the order and remand the matter to the trial court. But however, the petitioner shall pay the all arrears at 20,000 from the date of the IA till today, and by deducting an amount of rupees 7 lakhs that is already paid, and he shall continue to pay 20,000 per month by 5th of every succeeding month, pending consideration of this IA number 2 by the family court. Accordingly, this court is passing the following order. IA number, the order dated so and so, passed in IA number so and so, in criminal miscellaneous number so and so, is set aside, and the matter is remanded back to the trial court. Next, the husband shall pay the arrears at 20,000 from the date of the application, that's IA number 2, till today, and he shall clear the arrears within a period of 2 months from the date of receipt of the copy of the order. 3. He shall continue to pay 20,000 by 5th of every succeeding month. The parties shall file their respective statement of assets and liabilities as per the law laid down by the Apex Court in Rajneesh versus Neha within a period of 20 days from the date of receipt of the copy of this order, and from there on, within 5 months, the court shall decide the application. From there on, within 2 months, the court shall decide the IA.
Bill number 2 for orders. Akshita Shetty K for petitioner. Vivek.
For petitioner wife, my lord. The respondent has again failed to comply with the order passed by this honorable court on payment of cost, my lord. Kindly peruse the order sheet. They have for 2 years, last 2 years, he is not paying any maintenance to the wife and 2 minor children, my lord. And also, he has not paid
Where
the
is
cost.
where is the order of cost?
It is in the order sheet, my lord, 10,000.
I know which date it is. Who passed it? I have passed.
No, my lord. 4 hearing dates back.
Where is that order? Please tell the court the date.
I don't have the dates.
Please come. On 29/10/2024, the coordinate bench of this court has passed an order observing that learned counsel for the respondent seeks time. Lists the matter on 20/11/2024 subject to payment of rupees 10,000 payable by the respondent to the petitioner on next date of hearing. Thereafter, the matter came up on 2011, 9/1, 31, and 23/7/2025. On all these days, the matter was adjourned. On 12/8/2025, The matter was directed to be deleted from the caption dismissal. On 9/9/2025, this court had passed an order that the order dated 29/10/2024 is not complied with. That this court will not consider any of the contention of the respondent, and on that view, the writ petition shall be allowed. Directed the matter to be listed on 25/9/2025. Today also, there is no representation. Next, the writ petition is filed. Where is that order?
Page number 13, my lord.
Writ petition is filed, questioning the order passed on. I number 11.
Yes,
What is this IA?
section 24 application.
Is it I11?
I11, my lord.
I11. Dated 16 November 2023, whereby the court had directed to pay maintenance of 25,000 per month to respondent and two minor children. 25,000 to the wife and two minor children from the date of IA number 9 till disposal of the petition. What is the income of the husband?
My lord, he is working as an engineer at Singapore as per his own admission made in the cross-examination, my lord. Page number 19, my lord, para 17.
Page number 19 of what?
Para 17 of impugned order, my lord.
Yes. What is the amount you are seeking?
My lord, I have sought 30,000 to me and 10,000 towards my minor children and 15,000 towards house rent, my lord. And my one son is suffering with the mental disability, my lord. He needs a care.
So 30, 10, 10, that is 40, then
15,000 for house rent.
55,000.
55,000. And one more submission I would make, my lord. There is one CMIS filed in the year 2018. There is 20,000 is awarded, 15,000 to me and 5,000 towards one child. 15 and 5.
Then what did you do? Did you not
Sorry,
file
my
any
lord,
EP?
20,000 and 5,000.
EP. Execution.
Execution, not filed, my lord.
Why?
It is pending, my lord. It is pending.
Execution filed or not?
Not filed.
Why not? Why it is not filed? That's what I'm asking.
Proceeding is pending. DV proceeding is pending, and this is the divorce
The
petition.
interim order is not complied with. Will you not file? Want to seek implementation of the order?
That they have not filed. Some of the amount he has paid meanwhile, and from
What will happen now? That 20 plus this 55 will become 75.
No, my lord. 20 plus 5,000. It is 25,000, my lord. 20 plus 5,000. He is not complying that also. My problem is that, my lord, I have sought for modification of the order. The last part of the operation, this page number 22 may kindly be seen, my lord, of impugned order. The liberty is reserved in favor of the petitioner to deduct the amount paid in CMIS, my lord. So he is saying 25,000 is deducted towards that amount, and I need not pay anything in this MC petition. That is his claim, my lord. If he pays the 25,
So now, if this amount is granted by this court, he need not pay anything there.
that is his contention. That is why he is paying as good as I have not got any order in this MC.
No. But we can't grant this much of amounts, 25 there, 55 here.
No, this deduction.
No, no, when you file your statement of, your expenditure and what is the amount you want, have you in that have you shown this 25,000 that you are getting from the order that is already granted by the in criminal miscellaneous?
I have shown that, but I'm not getting that also, my lord. He is not complying that. I have shown that.
Clarify. That's what I'm saying. Either if you don't know, you want to forego that, everything will grant it here. And getting to 25,000 there, again 55,000 here, how can it be? That's what I'm asking.
I'll let go that, my lord. Anyways, he is not paying that. Any order may be passed on.
What did you say? The learned counsel appearing for the petitioner wife submits that in the DV proceedings, court had granted 20,000 and 5,000 towards the maintenance of the wife and the child, and that amount is not paid by the husband. And only a part amounts are paid. It is admitted that the one child is a special child, and he requires therapy, and for that she requires the amount. As the husband is working in Singapore, as he has failed to pay the maintenance, the wife is not in a position to maintain herself, the two children. Next para. No representation on behalf of the respondent. And in the preceding paragraph, this court has already observed that the the respondent husband has not paid the cost as directed by this court, and an order is already passed that the court will hear this matter and allow the petition. Next part. Having heard the learned counsel of the petitioner, there is a material on record. The husband is working in Singapore, and even before the court also, as per the judgment of the apex court, he has not filed a statement of assets and liabilities.
No, before any of the courts, he has
The
not.
liabilities. Once he fails to file the statement of assets and liabilities, then an adverse inference has to be drawn by the court, and the conduct of the husband at all stages appears to be to evade the payment of maintenance to the wife. In that view of the matter, this court deems it appropriate to allow this petition, and maintenance of an amount of rupees 55,000 is awarded to the wife as claimed for. However, it is made it clear that as this court has granted 55,000, the wife is not entitled for any maintenance from today, as ordered in criminal miscellaneous number 23 of 2018. When is this application filed?
DV miss.
This IA.
This IA.
She is not entitled for, because this order is from the date of the IA. She is not entitled for
27/6/2023, my lord.
she is not entitled for the maintenance from the DVC from the date of the IA in this case.
It is 65, my lord. 65, not.
My apologies, my lord. I appear for the
Over, I have
respondent.
already passed out.
My lord.
Sorry, my lord, I was held up in another court.
So many times you are held up. That's what the docket shows.
My lord, my one.
With respect to the costs also, my lord, the cost have been paid.
When?
It has been paid 3 weeks back, my lords.
She says it is not paid.
There's an online payment, my lords. In fact, the respondents
It's not paid.
to the respondent, my lords. The respondent stays in Singapore. So I've asked him to send me all the bank details of the maintenance amount.
In spite of an order on the last occasion, how casually you are taking the
No.
order dated 29/10/2024 is not complied with, is order on 9/9/2025.
My lords,
This court
in
shall not
fact,
consider any of the contention of the respondent. On that view, the writ petition shall be allowed.
I agree, my lords. In fact, the interim order of this honorable court, my lords, was to pay extra 10,000 rupees apart from the 25,000 which was awarded, my lords. The extra 10,000 along with the 25,000 which has been paid. It has been paid from 3 occasions. In fact, my lords, in all total, a lump sum amount of rupees 12 lakhs or 13 lakhs has been paid. All the details, my lords, in fact, he was not well. He is in Singapore. So he'll be sending all the details through email, including the bank transfers.
The client is not well, advocate is well.
Please, my lords,
Advocate can come to the court. That's what you're engaged for.
please. I had,
What is this conduct?
I'm really sorry, my lords. I was held up in another court. I could not come on
No,
time.
not only that, how many times the matter has come up before the court?
No.
I've already recorded all that.
No, my lords, I was being present, my lords, only.
At the request of non-counsel, the respondent released this matter.
It was only one occasion, my lords, I had sought for a time. And in the previous occasion before this honorable court, my lords, when I was asked to present the cost amount, my lords, I sought for some time because I had no instructions. This is a matter before the Mangalore because I did not have instructions whether the payment has been done in the Mangalore court or not. So that is the reason I sought. But if my lords may grant me 3 or 4 days, my lords, including the bank statements,
Why
my lords,
your client is not even aware that money is flowing into her account?
my lords, what is the reason?
Why she is not informing
After
you?
the last hearing date, I have inquired with the council, my lord. They said there is no payment has been. Have to take the.
Today you should have inquired by the time when the matter is coming today.
No, yeah, day before yesterday I have inquired, my lord. Day before yesterday.
Please inquire again.
Please, my lords.
Now I will allow this petition with cost of 2 lakhs. Pass over. Yes.
Chair number 3. Sri Shankar Reddy.
Hearing for petition
We had filed a memo, detailed memo along with certified copy of wakalat of the
What
council.
is this? Hmm. Where is that? The memo is filed stating that as per the order of this court, the petitioner had taken out handsome and served the same on the counsel appearing to the respondent, counsel Mr. Mohammed Kamran Khan on 14/8/2025. The memo is taken on record. When the name of so and so, this is matter after vacation.
Serial number 4, Sunil S. Narayan.
Petitioner Lordship, balance 24,000 is balance. I have paid 80,000 rupees total. Balance is another 23 months, excluding that litigation expenses.
Let's not go into all that. Please argue the matter.
Kindly, immediately, balance will be
it's
paid.
okay. So let it be. It's
The
an
balance will be
item
paid in
interlock-
another 24,000 is the balance.
interlocutory application. Why should we keep it pending? Other side counsel is appearing. We'll hear the matter. Please
Kindly
argue.
after, he will pay the balance and.
Let him pay. He has to pay. So please argue the matter. We don't want all that. And when the respondent counsel is present, we have to hear the matter. Yes, there is impute order. Interim maintenance of 10,000 to the
10,000.
applicant. Yes. What is your salary?
I am working as a, that is DTH connections. Per connection, I'll get 500 rupees per connection.
What is your income per month? There should be some income. You have not filed your statement of assets and liability before the court.
Both have.
Has he filed?
1 lakh.
Is his income?
That is what stated by the rest, but trial court has stated in that para number para number 10 of the impugned orders, para number 10, ink page that is 43. Though the applicant has urged that the monthly income of the respondent is about 1 lakh, but to substantiate even this fact, she has not produced any supporting materials.
How do you expect the court to come to any conclusion? What is your income without filing your statement of assets and liability? And why should this court entertain all this? Because the judgment of Rajneesh versus Neha is very clear. Parties have to file. The whole purpose of doing that exercise is to know what is the income. When you have consciously not filed all that, and as per the judgment, we have to draw adverse inference. And we will draw the adverse inference, whatever amount she claimed will grant. Because these family matters will not go on like this.
The only obligation, kindly have to immediately after occasion. I will get the further details. If that has been filed, I will get the 9th, have it on 9th.
So what is there in the order that you cannot improve by getting anything?
If they have filed the statement of that is not been forthcoming in the order by both the parties.
All should have been done by you when you're filing a writ petition before the court. And why the courts are entertaining these petitions without even the statement of assets and liabilities, in spite of repeated orders, they are not understanding that. This order, send it to R&S and ask him to talk to me. After vacation.
First one.
Yes, next.
Serial number 5. Serial number 5, Anuradha SK. For petitioner is recording.
What is this council submission? The present writ petition is filed questioning, seeking to quash a judgment and decree passed in OS number 293 of 2023 dated 15/7/2024, passed with the family court, and sought a direction to remand the case to the family court with appropriate guidelines to decide the matter afresh. Office has raised the objection with regard to maintainability of this writ petition. The counsel for the petitioner has made a submission that Section 19(1) of the Family Courts Act provides for appeal from the judgment and order passed by the Family Court, which does not bar filing of the writ petition invoking supervisory jurisdiction under Article 227 of the Constitution of India. If the judgment and order is perverse, whether the writ petition is maintainable against the order dated by the first edition Family Court is to be decided by the Honorable Court. In the light of the question of law raised in this writ petition, the office objections as per the same may be placed before the court. There is no representation on behalf of the petitioner, and the submission of the counsel is untenable. Under 227 of the Constitution of India, this court is not dealing with any appeal. It is only a revision. And the Family Courts Act is very clear, and against the judgment and decree, a writ petition under 227 is not maintainable. The office objections are sustained. The writ petition is dismissed, giving liberty to the petitioner to avail appropriate remedy within a period of 1 week, within a period of by 15th of October. 3 is directed to return all so and so. For the statistical purposes, the writ petition is disposed of. Yes.
Cell number 6.
For the respondent, Your Honor. In this case, my lordship, the petitioner filed the petition under section 9 of this seeking restitution of conjugal rights. The said application, wife has filed the application for seeking interim maintenance section 24 of the Family Court Act. And interim maintenance was awarded 8,000. That order was passed without any assigning, without any valid reasons. Which is
What is your income?
Yes, my lordship.
Your wife or husband?
I am an husband, my lordship.
What is your income?
My income is 18,000 per month. I am working in a non-government organization. Before that, the wife is also filed the petition under DV Act, where the 9,000 maintenance was awarded.
Was it disclosed before the court?
Yes, my lordship. It
Please
is not
come to the impugned order.
impugned order. Which is in page number 44, my lordship. There is no reason in the impugned order, my lordship, without any application of mine. The Family Court.
When is this order passed?
This order was passed on 16/12/2024.
16/12/2024,
my lordship. Under DV Act, the order was passed on 31/7/2024. Where under the DV Act 9,000 is already granted, and wife is also earning.
What is this order?
They've not submitted the bank statement before the trial court, Your Honor.
Discussion on that, whether he has submitted or not submitted.
And also both the parties are filed the acceptance liabilities.
Also,
the acceptance liability, she herself has admitted that she is working in a HDFC bank and she is earning 16,000 per month.
They've made false statement before this honorable court stating that.
Where from the court has to understand all this, that they made a correct submission or not. What is this order by the learned judge?
They've not.
This order also. Take a printout and send it to the.
If Your Honor peruses page number 65, Your Honor.
What is page number 65?
It's order related to DV Act, Your Honor.
That might be when the court is passing an order granting maintenance, court has to give reasons for what it is doing. He has not filed the statement that should be there in the order. He has suppressed the fact that there should be a finding. By way of a cryptic order like this, how can they pass order?
But previously, while submitting before this court, they have stated that they have been paying 9,000 per month. But whereas, yes, in the DV Act.
Where is that?
Yes, my lord. Under the DV Act, page number 65, my
Not page number 16. What is recorded by this court? I've recorded it while granting.
Yes, ma'am.
Order dated 6th of August, Your Honor.
Court had granted maintenance of an amount of rupees 9,000 per month and altogether is granted, it is submitted, the petition husband is earning an amount of rupees so and so. No, where is that it is recorded that he is paying?
Order point number 2, Your Honor.
Already granted per month and has submitted, the husband is already paying. Is it correct?
Yes, my lordship.
He's not been paying, Your Honor.
Under the DV Act, he's regularly paying the 9,000 month under the DV Act.
Instructions. It is instructions. First of all, take this.
Page
order.
number 65, my lordship.
No. Please show something, the password. The order immediately. With unless there is a meeting today. Yes, next.
Yes, my lordship.
Please
Pass
get
over,
instructions
sir.
with regard to the payment.
Pass over.
Pass over.
I have to secure the order sheet, my lordship.
Not order sheet, instructions. You have already submitted.
As per the
Before
instruction
court.
is regularly.
That's why I'm giving you one more opportunity to get instructions from the client. Then whatever if that is not, your client will be facing the consequences.
Yes, ma'am.
Ask the counsel, the party whether he's paying, so that I'll pass an order. Yes. You also get correct instructions. Yes, pass over.
Much obliged.
Yes, next.
Cell number 7. Yes,
My lord, I appeal for the petitioner in this matter. My lord, for the respondent, my lord.
Serial number 4, interim orders there. Kindly.
Yes. Serial number 4. Interim order. Yes, next.
Cell number 7. Yes, Hemant Bharadwaj.
My lords, I appeal for the petitioner in this matter. My lord, certain directions have been passed by the Honorable Apex Court. We are awaiting copies of the directions and the orders, my lords. Any date post vacation, this matter may be taken up. We are awaiting orders of the court. my lords. No, my lord. Some interim arrangements have been made, my lords. We are waiting for the copies, my lords. Any date post vacation.
My lord, the next date in the Apex Court is November 11th, my lord. Post November, we can submit the copies as well.
On 29th of October. Yes.
Please.
Cell number 8.
Yes.
Osmani.
No, my lord. Lord,
We are
filed
in
an
for the
application.
respondent, my lord.
Yes.
Filed an application for restoration of the matter, my lord. Since office objections were not complied, my lord, the lordship had directed to dismiss the petition if office objections not complied. My lord, when I got to go to the office, my lord, the file was not traceable, and my colleague has gone to Bijapur, my lord, for a period of 2 days due to ill health of his wife, my lord. Therefore, he could not trace the file. He could not compile office objection. However, DC, if everything was paid, my lord, an opportunity may be provided, my lord, to restore the file, my lord. Interim order of stay was also granted, my lord, in this case. And I have paid the 30% of the interim maintenance amount, my lord. And as directed this honorable court, time I am paying the interim maintenance amount also, my lord.
I number 2 of 25 is filed to recall the order 36/2025.
They didn't serve as the copy of the report.
That is, you were not even there on record by the time. Accordingly, the order dated 36/2025 is recalled. Have you complied with the office objections at least?
Yes, my lord. All officers are complied, my
This
lord.
matter immediately after vacation. Yes.
Much obliged.
Cell number 9.
My lords, I am appealing for the petitioner. My lords, my sincere apologies for appealing to VC. My lords, on the last date of hearing, this honorable court was pleased to pass an order directing me to take out hand summons, my lords. My lords, after consulting with the petitioner, I have learned that there is an FLW pending in the petition, my lords, and one more. They have filed criminal miss 479/2023 under section 128, my lords. In that case also, my lords, FLW is against the petitioner, so he is apprehending. He will be arrested or he will be thrown to the harassment, my lords. So may I request this honorable court to pass an order for court notice, my lords.
You have filed this writ petition on 11/7/2024. What is happening from that day? You have not complied with the office objections. A week's time is not there.
I'm sorry, my lords, but now, my lords, on every date of hearing, I am present, my lords, and I am doing my part of it, my lords. Yesterday also we had consulted with them because in 2 cases, and one, my lords, this criminal miss 479/2023 is
Next.
Serial number 10.
Much obliged, my lord.
Serial number 10.
IPF, sir.
Mohammed.
Right, Lordship kindly see, page number 21 is the order. My husband's petition, rupees 20,000 has been awarded per month to the wife. And the wife is also, she is MTech, he is employed, but in the assets, and she has produced the salary certificate, which shows rupees 54,000 per month. She is in Germany, but he is also in Germany, but now he is unemployed, my lord. I have stated in my objections clearly before the trial court. Page 21, this is the order, my lord. The IA straight away, without giving reasoning, IA has been allowed and awarded 20,000 rupees of compensation, my lord, maintenance, my lord. At page 100, in paragraph 34, I have clearly stated, my lord, I am unemployed, my lord.
Please come. Agreed with the orders passed in I number 2, dated 14/10/20. What are you doing from 14/10/2024 till now?
Pardon, my lord?
This order is passed on 14/10/2024.
Prior to this, but I am working, but now I am.
I said, what are you doing from 24 to now? After 1 year, you have come up before the court. Where is the impugned order?
Impugned order is at page 21, my lord.
Yes. When is it dated?
That is 14/10/24.
What are you doing from the last 1 year? Notice to the respondent. And please come.
Let's start our stay.
No, will not grant. This order also, take the printout and send it to guarantor. Today itself.
This is filed on March 23, my lord, 25.
And what is happening till now?
Under
Petition has not come up.
Right, under
there is no urgency for you. Notice to the respondents. Petition is permitted.
It was
to
under
take out,
office objection, my lord.
That is not the problem of the court. Take out the hand summons on the counsel appearing for the respondent and shall file a memo to that effect. Once the memo is filed, list the matter. Yes, Levin. Not this. In the end page. This. Yes. Next. Next matter.
Serial number 11. Serial number 11.
IPF for the respondent in this case, my lord.
IPF for the petitioner. Lord, last occasion, the lordship has passed an order, my lord. We're taking on record, my lord, that the sum of rupees 5 lakhs is paid to them, and further directed me to pay them 2,80,000, my lord. Check, I have brought the check, my lord. I am handing over the check. My lord, this is a case where, my lord, the wife had filed a divorce petition, my lord, and an application for maintenance was filed.
We'll have after vacation.
Please, my lord, if my.
My
lord, one submission.
1 minute. Has
One submission.
handed over.
My lord, one submission. Your lordship had last occasion indicated that, my lord, so far as wife is concerned, my lord, since she has suppressed the facts, your lordship will set aside the order so far as wife is concerned and remand it back to the matter to the family court, my lord, for reconsideration of wife's maintenance in the light of, my lord, what amendments have made in the writ petition regarding suppression of facts, my lord. So far as child is concerned, my lord, your lordship had indicated, my lord, 20,000 is granted. 15,000 your lordship had directed me to pay as arrears.
We'll see. As per the order of this court, an
Lord,
amount of rupees 2,80,000 is paid. The counsel for the petitioner has given a check or DD.
Check, my lord.
Check for an amount of rupees 2 lakh.
That 5 lakhs is
If my
encash, my lord.
I'll file a memo of calculations, my
Before
lord.
the court, before the registry, this is matter after vacation has part heard.
Yes.
The petitioner, the respondent submits that he wants to file the memo of calculation. The same should be filed in the registry.
Please.
Yes.
Serial number 12. Serial number 12. Bopanna.
After vacation.
Serial number
No
13.
representation. This is matter after vacation.
Serial number 13. Sampath A.
That's the wife's petition. It's in an enhancement maintenance application.
Please notice the
No,
respondent.
the one application was filed by the petitioner wife, my lord, seeking, my lord, retirement benefits documents needs to be produced. My lord, the respondent clever.
Anyhow, what is that we can do in enhancement now?
No, not enhancement, but the enhancement petition is pending. In meanwhile, she filed an application summoning some documents, my lord, to know the retirement benefits, my lord, how much amount the husband has procured.
Also, notice to the respondent.
Serial number 14.
Same, a memo, the hand summons on the counsel for the respondent, and shall file a memo. Once the memo is filed, is the matter is 14.
Serial number 14.
My lord. Husband, father is
Hey,
before my
Prakasham.
lords. Father has filed this writ, my lord, challenging the order passed by the trial court, partly allowing my application, IA number 6 for custody under section 38 of Special Marriage Act.
After vacation, take out notice to the,
My lord,
she is
I have,
permitted to take out hand summons on the counsel appearing for the respondent, and shall file a memo to the effect. Once the memo is filed, is the matter. In
Serial number
this custody
15.
matters, no ex parte orders.
no, I'm not asking for that. My lord. Could it be to hear on interim application posted on the,
After that,
please,
yes,
but my interim application is to be considered, that's it.
yes,
Please,
number
read.
yes.
Serial number 15. Meenakshi K.
The trial court has granted 10,000 interim maintenance, my lord. The respondent petitioner has suppressed the material fact, my lord, that she is working in a college as a lecturer and she is earning salary, my
Here
lord.
is the document. Take that.
This contention we have taken in the trial court, my lord. The trial court has not considered, and the trial court has stated that there is no income, my lord.
What is this?
That is the employees details in the college, my lord, and how much salary they are getting, my lord. She is working as a lecturer, part-time lecturer, and she is getting 14,000 salary per month, my lord. And she is also working in another college as a guest lecturer, and that document they have not given, my lord, given to us, my lord. In the assets and liabilities also, the petitioner has suppressed this fact, my lord.
What is this?
The serial number 2, my lord, Jahnavi.
What is this number? What is the number then?
Serial number 2, my lord, Jahnavi.
What is that number? Employees number.
She is working as history lecturer, my lord. The Padayuva Gauravadana, salary, my lord.
Which college? Accountant. What is the college? Which is the college?
Classification.
Girls High School. Girls Pre-University College, Arsenal.
That's the name of the college. What is the name of the college?
Girls Pre-University College, Arakalgud.
It's a government one. Please come. The present petition is filed. Agreed with the orders passed in IA number 2 in criminal miscellaneous number 13 of 2025, dated 6th June 2025, whereby the court granted 10,000 maintenance to the wife. It is submitted that according to the husband, the wife is working as a part-time lecturer and earning 14,000. This aspect was suppressed by the wife, and his contention and this particular allegation that's made by the wife was not at all considered by the court, and the court had granted maintenance. He has placed before the court the details that are issued by the college, that she is working in the college. In that view of the matter, there shall be stay of all further proceedings pursuant to the order dated so and so, so and so. The petition is permitted to take out hand summons on the counsel appearing for the respondent, and shall file a memo to that effect by 23rd of October. If the memo is not filed, the stay granted by this court stands vacated.
Obliged.
Serial number 16. Manjunath KV.
For the petition, my lord. This is aspect petition, my lord, challenging the interim maintenance award to the children, my lord. The trial court has awarded the 20,000 to the children's, my lord. Impugned order is, my lord, page number 58, my lord. The husband is working as a teacher, my lord, guest teacher, my lord, earning up rupees 34,500, my lord. Wife also working, my lord, she getting a 71,000, my lord. The trial court has, without any reasoning, my lord, 20,000 has been awarded.
Salary is?
My lord, our salary is 34,500, my lord. After deducting 32,000 something has come.
What is the wife's salary?
Wife's salary is 73,000, my lord.
73? Is it admitted?
Please, my lord, in the impugned order, my lord, in page number.
How many children? 1 or 2?
2 children, my lord. Madam, in para number
What is the amount granted?
20,000 has been granted, madam.
Please come. Then counsel for the petition submits that the husband is earning 34,000, the wife is earning 73,000. The court had granted 20,000 as maintenance to the two children. Considering the submission, they should stay of all further proceedings on the condition that he shall pay 10,000 per 5th of every succeeding month. Arrears also at 10,000 for a period of 8 weeks. Either of any of like common order is there. Just look at it. Any default, they shall be, the stay will be vacated, and even in this case also hand summons memo to be filed by 28th or whatever the date I've given, 28th of November in the earlier case. On that ground also stay will be vacated. Next.
Yes, madam.
Serial number 17, Anita Abraham for petitioner.
And
Kiran
for the
Sebastian.
respondent father in this matter, my lord, the court below has granted interim custody to me from 29th of this month to 5th.
That's her petition. Yes.
Please, well, I have come, I'm challenging the order of 19th of
Where is that?
September.
Where
It's
is
on
that?
page 26, annexure A. Well, it's effectively parties were married in April 2008 and they were initially living in Gurgaon. Child was born in 2000.
1 minute.
I'm
Let
sorry,
me look
please.
at the order. Please come to the order.
May I read?
Read the operative portion of the order.
All right. Maloj, the respondent husband has filed had filed an application.
Come to the operative
All
portion
right,
of the
all right.
order
Yes,
and
yes,
read.
yes. He had filed an application for 20 till the 7th of October. The order on page 29 reads, IA number 3 filed by petitioner or under section 12 of the JNWC Act is hereby allowed in part. Petitioner is permitted to pick up the child from the house of the respondent at 8 a.m. on 29/9/2025 and have the interim custody till 6 p.m. on 5/10/2025. Petitioner has to take care of the child, including the health issues of the child, and inform the mother with regard to any ill health during his custody. The petitioner has to drop the child to the house of the respondent on 5/10 at 6 p.m. accordingly. Well, the child interacts with the father sparingly, like half an hour once a week, but he is devastated and extremely uncomfortable at the idea of having to be forced to go and live with his father. This entire case has a history of domestic violence, where in 2000, they were married in 2008, 2012, the child was born. Please.
Before that,
yes.
From what is the age of the child?
So he's 13, please.
13 years.
Yes.
When the disputes have started between the parties?
The dispute started, the legal dispute started in 2019 when a divorce petition was filed by her in Kolkata and West Bengal.
And from that day, they're staying apart? Or
They actually, no, the factual dispute in terms of filing police complaint started in fact in 2016. So there was
2016, they're not staying together.
They are not staying together.
February
And even from 2015, they are not staying. From 2015 January, they've not even cohabited as husband and wife. From 16, there was such a aggressive and violent incident that she was forced. They were living in Gurgaon. She was forced. She was hit, thrown out of the house, and she, having no choice, she went and stayed with some friends. Yes. The child was about 3.5 years old at that time. He locked the child up and said, "You cannot take the child. You cannot do anything." She was barely getting into her senses when he made a call to her on 19th February. Yes, just one.
Not detailed,
yes.
We don't require for deciding
yes,
this
yes,
application.
I agree,
So,
yes.
2016, from 2016, they're staying.
They are
where
staying.
is the wife staying?
Wife is right now, so in 2018, she moved to Bangalore, right now staying in Whitefield in Prestige Shanti Niketan, along with her aged parents who are 85 and 75 years old. And child is also
Husband
with them.
is residing there?
I'm sorry?
Husband is residing
Husband is in fact living in JNU. He is he's working in IIT. I'm sorry, in Delhi. He's working in IIT in Delhi, and he's has a fully established job. He comes on weekends to interact with the child. He keeps it. Yes.
So, when is the GNWC file?
2020.
2025.
Yes, by the
from 2016 to 2025, what are the arrangements between the parties with regard to the visitation of the child? How often the visitation is taking place?
Well, it's visitation maybe once or twice a week, because at some initially when after she was forced to leave
right
the child.
From 16.
I'm sorry.
Right from 16.
Right from 16 on a weekly basis in a kind of interactive way, maybe for half an hour to 1 hour or even a little bit more. She was actually quite okay with him interacting with the child.
This interaction is physically is visiting or over phone?
So since she moved to Bangalore, he comes in the weekend to physically meet the child, always under the supervision of the petitioner mother, because the child is not comfortable with him. He's also intimidating, he's aggressive. Many times what he will do, he will fix to meet the child, and when the child calls him, he's not available. So in the last, so what has happened, Manoj, in fact, in 2018, after she moved in 2020, he filed this GNWC petition. Thereafter in 21, she got a job and moved to Mumbai. So I filed a transfer petition in the Honorable Supreme Court. Supreme Court allowed the transfer petition, and during that time, vide an order of December 22, had stressed that let the parties mediate the matter. Mutual consent divorce petitions were filed twice, once in 2015, once in 2017. Did not go through due to the always a backing out of the respondent. He has not been paying her any alimony, not to raise a child, not for her expenses.
You're not coming to the point.
Yes.
Yes.
So please, Malab, so 2022, what had happened?
What I want to know is only with regard to the child, not any other issues.
All right.
Now,
yes.
From 2016, the father is meeting the child. Once she moved to Bangalore in 2018,
yes,
he is coming on every weekend. What is the duration on every weekend?
Maybe for about half an hour.
Half an hour where?
Half an hour in her house. He comes, picks the child up. Sometimes they go to play tennis, because he has also taken up a place on rent in the same apartment complex.
They take him out.
Yes.
Always
within the apartment complex. In fact, yes.
So this is happening from 2018 to 2025.
Yes.
Then in 2025, father has filed the GNWC.
Please.
In that, when is IA filed for? But when is this IA number 3 filed?
I think on the 12th of August, he has filed it.
Now we will ask him. Yes.
Please.
I deny all these allegations. It's only to mislead the court. Marriage is taking place in 2008. Child is born 3/10/2012. Child is a male child. Today is 13 years. February 2016, she deserted me, taking the child. February 2016. Since then, I've tried my best to settle issues. I filed a case in 2020 for child custody. She goes to Bombay, transfers this case to Bombay. Then she comes to an agreement stating that 50-50 child custody, summer, all those holidays.
So you have already filed GNWC in the year?
2020. This is the same matter which has come back.
20 in Bombay.
No, Bangalore. In Bangalore, family court. This matter was transferred by her to Bombay. And after she comes to an agreement, then what she does is, again she goes back to the Supreme Court, transfers it back to Bangalore. Now at page number 91.
He numbered as 2025.
Yes, my lord. So now I'm running from pillar to post. And for the past 8 years, every week, I work as the CEO, Technical Department, IIM Delhi, set up by the Government of India. I'm the CEO. Now every week I fly down and see the cost title. I've taken a house in the same complex. She's at tower, I'm at tower 1, she's at tower 10. Every week I've been flying down to see my child. She doesn't do that. All my emails that I send to her, she shows it to the child. Yesterday I get a call from my child. I was this zone. I couldn't pick up my call. No signal zone. 20 calls. And the child tells me that you have lost a friend. You've lost a son. He's been tutored so much. For what reason?
What he says?
You have lost a friend. You've lost a son. Why are you lying to me? Then when I asked him, what are the lies I've given? The phone is cut abruptly and she doesn't pick the call. All the emails that I sent to her, she's showing it to the child. Now, at page number 91, in fact, this sharp unfair practices, copy is given to me, but only till page number 81. And yesterday at 6:40, she sends an email with the entire file. Be that it may be,
It was a mistake. It was a...
Yes.
At page number 91, Supreme Court transfer petition. Para number 8, the last 3 lines I would read. It was expected that the parties will amicably resolve the dispute, especially when the petitioner wife has not sought for financial assistance for herself or the child. Now, at para number 12, my lord, of the same transfer petition, which is at page number 93, the transferee court shall make a fresh attempt for amicable settlement of the dispute between the parties through mediation. In this regard, the transferee court shall consider the respondent's prayer for visitation rights and interim custody of the child, keeping in view the best interest and welfare of the child in mind. Trial court has rightly passed the orders. I asked from 20th to 7th. The court is given from 29th because she said the child is going to Hyderabad. Okay, the child went to Hyderabad and came back on some excursion trip. Now, every week I'm coming. I'm spending so much. She does not want financial assistance. In spite of that, I've got his permission to stay that 50% of education we're ready to pay. But why is she not showing me the child? It's because there was a male partner. There was allegations of adultery. She has traveled and I traveled behind.
His allegation, she's been living with her
What is
aged
this?
parents from
Same
2017.
attitude in the court. She
They are
won't let
stuck
me speak.
from the beginning with one allegation, adultery.
I did not want
Some
to bring
man-
that up over here. It
It is even questioning the morals of the
it is
petitioner and her
welfare of
entire
the-
family. So
welfare.
which is why such a man should not be given this full week. Last time they came and said he only lives here, he does
welfare
not
of
live
the
anywhere
child
else.
is of paramount
He has a
concern.
full
She's
On the
put-
court to hear the matter, there is a procedure in this court to hear.
I apologize.
Yes.
Yes.
welfare of the child is of paramount concern. See the grounds. Danger. 2016, she has given some statement to the police. Over there, I may read it out at page number 81. Yesterday night, in the intervening night, so-and-so date, I received a call from my husband saying that he shall end his life as well as the life of our son. These are all allegations that need to be proved. She has to produce the recordings. Nothing, no FIR file, nothing. And then she's running around from Bangalore to Bombay, Bombay back to Bangalore, misleading the Supreme Court also. When she has given submissions over there. And the court, Supreme Court has also stated that the court shall consider the application. And you tutor the child's mind. You show him all the emails. I get calls from him. Where are we heading, my lord? She doesn't want me to spend time with my child, and he's a boy child, 13. There's no drastic allegations. There's no allegations of any sexual conduct, nothing of that sort. She just doesn't want me to spend time with the child. She's using the child as ammunition, my lord.
My lords, may I just make a submission?
And she says that I'm living in Delhi. She's filed this writ petition, page number 4. My address is Bangalore.
Yes, I have.
My
yes,
address is
Manoj, I have the
Bangalore.
photographs of his job, of his office in IIT
I am-
Delhi.
I am the
Top
CEO.
profile.
I am the
Let him
CEO.
put on affidavit. His entire future will be compromised because he's CEO of IIT Innovation Hub based in management studies.
Saying so.
Yes, I'm
Where is
admitting
he
that.
denying it?
Please.
Where is he denying it? He says he's working in Delhi and he's coming down to Bangalore.
Yes, Manoj, and just one, I just want to make one more submission. He is saying I'm not allowing him to meet the child, which is completely incorrect. Every
Why
week.
should he see the child only for half an hour when he's coming down to
Manoj,
Bangalore
for this,
2 weeks?
yes.
No, you have traveled to Bombay, Bombay to Bangalore, Bangalore to Bombay, again to Bangalore, and he's going around the courts and he's making all the efforts to come from Delhi to to Bangalore. Why is he not permitted to see the child? Only why is it for half an hour?
Please, Manoj, in fact,
Whatever has
I've
happened,
never restricted.
whatever
Yes,
has
yes.
happened, it has happened when the child was 3.5 years old. Unless and until the mother tells him what has happened, he wouldn't be knowing it. So we have to presume that the mother is polluting the mind of the child with unnecessary details, which he doesn't have to, which are not at all required for the child.
Manoj, not at all. In fact, I'm the one who set up Google Hangout so that child can speak to his parents. I have set up a WhatsApp group, Google Hangout, so that he can speak to the child.
It shouldn't be agreed by this.
Manoj, but all I'm asking is that then my lords may just speak to the child because the child is he's crying all night at the thought of going to father or overnight. Yes, Manoj, may I say overnight custody may not be given. Let him come meet the child during the day, however long he wants. But the thought of being outside of and staying in this man's house where he's not lived till now, it would be for 7 days continuously out
Why
of
the
the blue.
son is calling the father with all this when why the mother is trying
Manoj-
to show what has happened between them to the child? Is it not detrimental to the interest of the minor?
She has never done that. She has not done that. The
If
only
she has
reason,
not done it,
yes.
if she has not done it, when they have not lived together from the age of 3.5 years, no child will remember the things that had happened at age of 3 till 12.
Manoj, whatever it is, can it be done steadily? That is all I'm asking. Overnight,
How it
suddenly
will happen?
dragging a child.
No,
Manoj,
how
what-
it will happen? There should be a change from your client's side. Let her keep all her emotions, all her pains to herself.
In the meantime,
because neither
yes.
of the parents
Manoj,
have
if
any
a short
right.
date, yes, all I'm asking is if a short date can be given in the interim, let the child just be spoken to once. My lords, and then Manoj,
I know what will,
yes.
even if the court speaks to the child, what is that he will tell that I can understand.
Because Manoj, if
I've
he's
speak
going to be
so
yes,
many children.
yes, Manoj, all I'm saying is suppose he's going to be crying all night for 1 week. Is that what we want? Supreme Court has repeatedly held, including Section 13 of the HMGA, it is no order against the welfare of the child. Even in this particular order read
If the
by
court
my lord,
feels that, if the court this court is of the view that the manner in which the child is, like tutored, is not in the welfare of the child.
No, he is not
Court has to-
tutored.
Court has to
As
look
I
at the
said,
interest. Please tell one thing to the court. Father is bad. Yeah, unlike he's a bad husband. He did so many things to the wife.
yes,
Yeah.
yes.
Domestic violence is there. When all this has happened, the child was 3.5 years old. After that, they were never staying together. On and off, as you submit, he's having the visitation for just half an hour. In that half an hour, what the child understood about how bad is he, about all these things, unless and until the mother is telling him about what has happened, what is he, and what is happening between them.
No, she does not. In fact, that's what I'm saying. I am the one who's constantly telling him. In fact, when I moved here to Prestige Shanti Niketan, I'm the one who even helped him get a house.
And something is happening for 24 hours, you're telling him something, and for 10 minutes you tell him, go and meet the father.
All I
Why
did,
will he
no,
meet?
I was just that because that is the outcome of what I prepared him for. I told him that he will have to go and spend time with his father next week. In fact, on Ganesha, I told him, go with your father in the apartment complex and see the festival. Then he refused and he shut himself in the door.
Meet? 24 hours, like whenever he is with you, you're going around, showing him all the emails, talking to him.
That is a complete
about,
lie. I have never
then
done
why is he
that.
understanding? Then what is the, unless and until something is shown to him, he doesn't have any one-to-one contact with the father to understand, or he's not showing the emails, he'll not show.
All I'm requesting is, let it be done with some balance. That is what
First of all, there should be a change from your client. Let her show the, like, let her make the child understand the things in a positive way. And she has to understand she's doing all this at the risk of his future, his welfare.
Yes, Manoj, all that I can place on record. There is an entire history of their conversation with each other. She has never stopped it because it's all now online. I can put all that showing that I have relaxed.
Let it continue. Let the father and
but not
child
overnight
have the
custody.
same.
That's my only ask today. If it cannot be over, or maybe one
Why
night
he will
overnight
forget
custody.
all that
I'm
what
sorry?
is told by mother if he is with the father?
Manoj, I don't.
If he is completely with the father, he may lose in touch with what all bad things about the father.
Well, it's not that. I think he will be traumatized. There's nothing else. Let us, as I will bow down to what this court is saying. Let us, yes, say fine. Let the child also, because as I said, she herself is saying, she herself has opened out, kept these avenues open throughout. And so all I'm seeking today is that let the child not be traumatized. That 1 week just for between
Why
the
is he being traumatized? What did the father did to traumatize him? Tell one reason that I want to
he's
know.
not comfortable with the father. So let that process
So
begin.
that's one common word, not comfortable. For not being comfortable, there are reasons. And what are the reasons? Reason is prompting by the mother.
No, it's not
Nothing
at all.
else.
Not at all. So all I'm saying is let there be a balance. That's my only request today. Otherwise, even in this order, it says that the welfare of the child is, in fact, there should be no adverse psychological effect on the child. That's what the Supreme Court has held in this particular matter.
First of all, let us understand the facts than the law.
Yes. So
the law by the Supreme Court or this court has to be applied to the facts of the case. So as it is, we can't apply it.
Please, Manoj, as I said, there is no problem. 29th to, and that too, on 6th, his school reopens. But despite that, the judge is given till 5th evening. And he's, yes. So all I'm asking is that overnight custody can be 1 day. Rest, because anyway, he's in Delhi.
Let the child also has, let him enjoy the company of the father in Delhi.
Fine. So maybe 1 day at the beginning, maybe Monday night and Friday night. Rest of the days, because anyway, he himself is in Delhi. Rest of the days, let him come whenever he wants during the day.
But that's what he has been doing. That's what he has been doing from years.
All I'm saying is let it be 2 nights. Let us start with this. Child is only 13 now.
No.
Yes.
And it has happened. That's why I asked you the details of how it is happening. Right from 2016 till 2025,
yes,
this weekend business is going on. He's coming down, he's seeing the child, but it's not making any difference. As you say, we have to take it slowly. We have to understand the psychology. Now, what is happening is, the more he's growing up, now he's 13 years old. What could not happen between 3.5 and 13? What would happen now? Unless and until he's given enough time with the father. Away from the mother.
Yes. Manoj, this can be taken. All I'm saying is let it be taken slowly. Through the day.
How slow you want
Manoj, then suppose it works out. Then the advantage is for him. Because maybe next vacation he can say, fine, 2 nights the child was fine. That's all I'm asking. He's a 13-year-old boy. He's
13 years in today's era. 13 years is too independent and too old.
Yes, absolutely. Which is why he also has a mind of his own. And no parent, no grandparent can tell him. But also all I'm saying is let it be for 2 nights and rest of the time let him come whenever. That's my only request today. And then in the meantime, this matter can also be mediated. She's not asking for alimony. Let it be closed 10 years.
Please, why is it not closed till now?
I'm sorry?
Why is it not?
Manoj, I don't know. Respondent has refused.
Yes, what is,
She has filed a divorce case. Let
Ah.
everything be settled, my lord. And also, with regard to the child, he is independent enough to stay out. On her own submission, he has gone to Hyderabad on a school excursion from 20th to 23rd of September. From 20th to 23rd of September. Already what I've requested has been watered down, my lord. Now, and 5th, 6th school is reopening, but this is not the academic year. It is just a continuation. So there's just after the exams this is. So he's not going to lose out on any of the syllabus, my lord. Spending some time with me, he's not going to spend. And he also, I have to take him and meet all my relatives also.
Manoj, all that can happen slowly. All I'm saying, this is the first time it's happening. He's a 13-year-old boy.
no, don't have to say
Yes.
it again. and
So
again.
all I'm saying is, Manoj, he will really be very sad and upset. So do we want, even for the father should try to say, okay, fine, not, let me not pressurize him and make him be crying all night without his, his mother.
No, father do not want the child to cry all night. He
Yes.
will take care of him. Don't
So
worry.
Manoj, all I'm saying is let it just be 2 nights, and during the week he can come and meet the child whenever he wants. Anyway, he's living in Tower. Yes.
When the child is with me, I don't mind her calling at any time, my lord. Video call or voice call.
When the holidays are starting for the child?
It's already started on the 20th of September.
Hmm.
So last 1 week is past.
So he has gone to Hyderabad and come back and he's
He
spending
went on a
time.
school trip. Yes, that was booked in July. I have paid for the entire thing. Per year, I'm paying close to 8 lakhs for the child's school in Greenwood High School, he's in 8th grade now. And the father only now suddenly he wakes up from his sleep and says, okay, I will give half tuition or what. Yes.
Let's not go into all that.
No, the child's birthday is on the 3rd of October. So if he can be with the mother on that day.
1 minute. What we do is, the child you can have the custody of the child on 27th, 28th, 29th, and 30th. Let him, you please, on 31st and 1st happens to be Saturday and Sunday. So as it is holiday for you also, you come down and then celebrate the child's birthday on 2nd and 3rd, or if you celebrate on 2nd or on 3rd, till 3rd you have the, 3rd is the child's birthday. So 31st and 1st also here in Bangalore have the day visitation, day custody, night custody will be with the mother. Celebrate the birthday together and you can leave.
My lordship,
So
he has traveled with his friends, having night custody, not a girl child, boy child, 13 years old. He needs the father, he needs
You're
to
going
understand
to
the
have it
father.
in Delhi, 27, 28, 29 and 30.
No, it's Delhi. He's not
Delhi,
even asked.
obliged.
His whole ask is only in Bangalore.
That is to take
He's
the
not
child.
even asked. He himself is saying he's always permanently.
No, where did the court say?
Custody, give him
Custody, and
interim
that his
custody.
address is clearly only.
Where is that application? Where is the application?
I'm the one who has brought up the fact that he was in Delhi. In fact,
No, let's read it. What did he say?
I've asked for 29, 2025 to 710, 710,
Granting
20. That's being
sole and
part of the
permanent minor child to his
unsupervised
father.
and independent custody of the minor child.
Respondent not to leave or take away the minor child from the jurisdiction without permission orders from this. The respondent forthwith return the minor child to the custody of his father. Yes, so it is in Bangalore. So you can have exclusive custody on 27, 28, 29, 30th.
well,
Obliged.
till 29th
Obliged, my lord.
it will be too much. 4
Yeah,
days.
and 31st and 1st, let it be a day visitation, day custody. In the night, let it be with the mother. Then on 2nd or 3rd, whichever is the day, if the birthday is on 3rd, if you want to celebrate birthday on 2nd, you celebrate. 3rd, you will be with the mother. Or you want to celebrate it on 3rd, 3rd we will grant.
One request, my lord. 27, 28, 29, 30, I'll have custody of the child. 31st and 1st, I will have day custody. On 2nd, if I may be permitted to take my child in the morning and return him at 1 o'clock on 3rd, so that intervening
No,
night,
Manoj, that is
birthday
too much.
night, this will be the first birthday I'm spending after so many years. I want to spend.
We'll do that something. On 2nd, you
Second
take
morning,
him-
I'll take the child, return him.
take him in the evening at 7 o'clock, drop him back on 3rd morning.
Yes, my lord.
And she will celebrate
At
the
around
birthday
11
on
o'clock, I'll
3rd.
drop him.
You celebrate the birthday in the night.
Yes, my lord. Yes, my lord.
But also, the child also has classes. So
Classes when?
He has classes at 5 p.m. I have put it in
He
my.
will he will take him to the classes wherever it is. He's here. He will take him to the class wherever it is.
All right, he may come. Manoj, but
Whatever
cannot, all
whatever
right.
are his academic
Yes, well, Manoj, may
extracurricular.
it not be on 2nd because his birthday was on 3rd. Anyway, there are 4.
No. Third, let mother celebrate the birthday. Second night, he will celebrate.
All right, then can it only be 27th and 28th? Just to give some, Manoj, I'm just asking, let there be some balance. That is my.
That's already, court is already balanced.
I'm sorry?
The court is already balanced.
Manoj, yes, but can it not be till 30th? Then it's as good as giving the entire week to the father. So my only request is let it be 2 nights, 3 nights in total.
I number 3. It is like, is it a tour package? 3 nights, 4 days.
Please,
Agreed
Manoj,
with the
I'm
orders
trying to
passed in
minimize
line number
the,
3
yes,
in
the trouble to the
number
child. That is
42
the
of 2025, whereby the court had granted the complete custody to the father from 29/9/2025 8 a.m. to 6 p.m. on 6/4 on till 5/10/2025 6 p.m. The mother is before this court. The court in the order has also observed that the father has to take care of the child, including the health issues of the child, and inform the mother with regard to ill health during his custody. And he has to drop the child to the house of the wife to the mother on 5/10/2025 at 6 p.m. Next parallel. And counsel appearing for the respondent, for the petitioner mother submits that the boy is 13 years. The dispute started between the parties from the year 2016, and they have been residing separately. And from 2016 till now, the father was having only the visitation during the weekends. If at this stretch, by this order, the court had granted the visitation of complete custody to the father, which is not in the interest of the child. It is submitted that the child is not comfortable going to the father. The learned counsel submits that if it may be restricted to 2 or 3 days. 3 days, and court has to consider the welfare of the child, and also the fact that he is aged about 13 years and he has his independent mind and he can exercise and he can ask, and his wishes also have to be taken into consideration. And it is also submitted that anything that's pertaining to the child, it cannot be imposed on the child and it has to be taken slowly. And the emotion and it should not have any emotional effect on the child. All these aspects were not considered by the family court, and the court has passed an order which is not in the interest of the child. Hence, the same needs to be modified. Anything else?
Please. Manoj, yes.
Expert. Learned counsel appearing for the respondent further submits that they're staying separately from 2016. As on the date, the boy was aged about 3.5 years. And after that, she moved to Bombay. There she has filed a GNWC seeking there he has filed the GNWC.
My lordship, it was filed in Bangalore. Originally, the custody
It was
case
filed in the year 2020
by the father in Bangalore.
In Bangalore. Then the mother has shifted to Bombay, and then it is transferred to Bombay. Later again, the mother has came back to Bangalore, and the same was transferred to Bangalore, and that is denumbered as GNWC number 42 of 2025. It is submitted that right from the day he has taken an apartment in the next building, and
Same complex, madam.
in the same complex in the next building, and he has been traveling to Bangalore from Delhi on every weekend to have the custody. It is a submission of the learned counsel appearing for the father that the mind of the child is completely polluted, and whatever are the differences between the father and the mother my mother has been discussing the same with the child, and that is having a bad impact on the child. It is submitted that the court rightly considered and rightly granted has passed the order. No interference is called for. In response to that, learned counsel for the petitioner submits that all those allegations are denied. It is submitted that the mother is not doing anything of that nature. And as he is old enough, he can understand the things and he can take his own decision. Next para. And it is always the mother was always trying to see that the father spends a good time with the child spends a good time with the father. Next part. Having other counsels on either side, produce the material on record. The disputes between the parties have started in the year 2016 and admittedly as on the day the boy is 3.5 years old. Even assuming that there is a domestic violence and the father had been back to the mother, that is not the age where the child can remember all these things. And the submission of the learned counsel that because of all this, the boy is not comfortable with the father. This court is not able to appreciate the said submission. And the next submission that all these things have to be taken slowly. When the visitations are happening from 16 to 25, that is from the last 9 years, but how slowly it has to be taken, this court is not able to understand. Admittedly, father is coming every weekend to meet the child. And why the father is being granted a visitation for a very short time, all these years, this court is not able to understand. Unless and until the boy able to spend some time with the father, he will not be able to understand what is a father, and he is more carried away with whatever the impression of the mother on the father. In these circumstances, giving a considerable time for the father to spend with the child, in the considered opinion of this court, is a very reasoned order. However, considering the fact that this overnight visitation is happening for the first time, this court deemed it appropriate to modify the order of the family court. Accordingly, this court is passing the following order. Number 1, the father can pick up the child on 27 at 10 a.m. and he can have the exclusive custody on 27, 28, 29 and 30.
No, he may be dropped back on 30th morning. May he be dropped back on 30th morning.
27, 28, 29. On 30th, the boy shall be dropped by afternoon 12 o'clock. And on 31st and 1st, the father can have the visitation between 2 to 9 or 10 to 7.
I think 12 to 5 is possible.
I said only 2 options.
Okay.
10 to 7 or 2 to 9.
My lords, I think 10 to 7 may be better.
He can have the day custody between 10 to 7 on 31st and 1st. Next, number 3. On 2nd, it is submitted. The 3rd is the birthday of the child. Such on 2nd evening at 7 o'clock.
My Lordship, there's no 31st in this month, September.
Oh, yes.
Yes, I've looked at October, I think.
My lords, then the time may be shortened because it's even more. Yes.
1 minute.
And 2nd is not necessary at all. It
Yes,
will
I
really
said,
upset the child.
Please wait, please wait.
2nd, let him just get day. On 3rd, let him just get day custody. That's my
27, 28, 29, 30th. Then 1st, he will have the day custody. The father will have the day custody. And on 2nd, from he can take the child at 7 p.m. and drop him back at morning 7 o'clock.
My Lordship, on 3rd, if I can drop him at 11 o'clock, night I'll celebrate it.
On 3rd, drop him back by 7 o'clock to the mother. The mother can celebrate the birthday.
Well, it may be recorded that he may not take the child outside the jurisdiction of this court.
The father is not permitted to take the child outside the jurisdiction of the court.
Well, is there a chance of settlement? My learned friend may...
The parties shall appear before the Bangalore media or a senior counsel.
A senior counsel, I think, if my lords can appoint.
Joe Joseph is the mediator. I recommend Joe Joseph as a mediator. in
Someone
mediation.
from the Delhi High Court, any senior person is fine, whoever.
No, we have
is
Joe
recommended.
Joseph as Mr. Joe Joseph as senior mediator in our family court. Maybe
No, let.
Manoj, we already tried once in the family.
Sushila,
my lordship.
senior counsel Sushila,
I'm not comfortable.
you are not comfortable. Your party should be.
No, I have
comfortable, not
cases
you.
against her. So she's my adversary in court matters.
They
There
shall
is in
appear
the-
for the Bangalore Mediation Center
Obligement.
on 15th of October.
Obligement.
Both the parties shall appear before the Bangalore Mediation Center.
I'm grateful. Manoj, in case a child is traumatized, the father may keep that in mind. If it can be recorded.
So whenever the child wants to speak to the mother, the father shall ensure that the child speaks to the.
Or seen and see the mother. if
And
it can be.
by video, audio calls.
Or even physically, because they are neighbors.
By video, my lord. He's going out, see, when we say,
Manoj, he may not be restricted because already
again
now
she
this
would
is
come
being
and she'll
imposed.
sit over there,
Let him
land
not-
up in the police
because
station.
they
See,
are
this is,
neighbors, let
she's,
him not be
I've
forced.
been keeping quiet the whole time she's going on.
Video and audio calls.
And let him not be restricted.
Two times in a day. Yes.
Manoj, let him not be restricted meeting the mother.
Yes.
It will be like one jail
No,
otherwise.
Not required. Yes.
Yes.
He's going to his father. He's not some. Yes, next.
Cell number 18.
Obligement.
Denial. 18.
Yes.
What's the issue, my lord, revolves around, my lord, the issuance of warrant. But this is a matter which my lords have reserved, my lord, on Monday. But the RPF is filed and pending before the Honorable Court. But petition is filed.
Same matter.
Same matter, my lord. Arrest warrant has been issued. FLW also has been issued simultaneously. But lords are aware, my lord, under 125(3), not unless, my lord, the attachment, etc., proceedings are undertaken, not question of issuing arrest warrant does not arise. That's what not held by Allahabad High Court. What they have done is, not the court not passes an order and says not that not NBW is issued, and also, my lord, FLW also is issued.
What will happen if it?
But in fact, not both cannot be issued. If not, kindly see section 125(3) for a moment. Not,
So we'll say that one should be effected.
please, not.
One should be given effect
Not
to.
unless not the attachment of property, etc., is first not attempted to, because there has to be an inquiry.
First
No
of all,
inquiry
a
not has
party-
taken place.
If a defaulter time and again comes to the court and says that that is not right, this is not
No,
right,
Lord, I'm-
and court will be entertaining this petition.
Lord, if I'm on a question of law, not if not kindly permit me to just show not section 125 for a moment. Here, not the wife in her affidavit.
Hear it after vacation.
Not can I just persuade the Lord, could please turn to page 160 for a moment.
We'll hear it after vacation.
No, Lord, my urgency is not because the arrest warrant has been kindly turn to page 160
Court
for a
has no
moment.
work but to deal with your client and his wife's problems
But
all the time.
what not-
Every alternative day, one petition to the court.
Not every alternative day, Lord.
And
What
you don't do what you're supposed to do and come to the court every day that legally this is wrong, legally that is wrong.
Lord-
And when you are morally and otherwise you are wrong, that you know you don't do.
But I
anything to
have
the
paid, Lord, maintenance, Lord. It's not that I've not paid. Lord, but kindly see what the court note has ordered. Lord, it is ordered my salary is 42,000. Court orders 2,80,000 per month. Lord, from where do I give that money?
That only you pay.
Lord,
What you can do?
please, Lord.
You pay 42,000.
But that is my salary, Lord. That is what I'm earning. But kindly permit just take to go to 160 for a moment, page 160. Her affidavit filed before this Honorable Court in the RPFC. Para 21 for a moment, Lord, for kindly see. Page
Can
160.
also come, we will see, we'll hear her.
Lord, page 160, para 21. For a moment, Lord, for kindly see. She has the funds, but I don't have the funds. My difficulty is that. Please turn to page para 21 for a moment.
It is not about her funds. We are only concerned with the order.
True, Lord. The court note is,
Order and implementation of the order.
but implementation, I can understand not if the order note is something reasonable. But kindly see the order as well.
Because
Court
what to
says
do,
not
court
foreign
has-
trips, I have to sponsor her. And her own pleading is that, Lord, I have suffered loss. Lord, what she does is, Lord, there is another suit that she has filed where she says the transfer of the property in my favor is bad in law. Her pleading there is that, Lord, I have suffered loss. She took over the business. But now, Lord, before in the court, Lord, seeking for maintenance, she says, Lord, I am liable to pay this amount. Please turn to para 21 at page 160 for a moment, Lord. Kindly see, Lord, one paragraph. Then I'll take, Lord, to the provision. So para 21 of her own affidavit, she says that I spend around 5 lakhs to 6 lakhs per month towards my travel to and stay in Bangalore and for weeks together, depending on the case hearings, food, hospitalization, routine medicines, etc. But she's spending 5 to 6 lakhs is her affidavit. But if she has 5 to 6 lakhs per month, she's spending, but she has sufficient enough source of money. But I don't have that kind of
It
money.
has not started today. It started in the, which year? 2012 or 2011?
2012 or so, yes, Lord. 2011 or 12. But kindly see, for a moment, kindly see the order, not the trial court. What the trial court says
Go to
is,
Supreme Court, you will come here, you will do, and suddenly you realize that you're into losses, and then you ask for a
no, Lord, it is
modification.
her own pleading, but I will not rely upon my pleading.
No, suddenly you will not, when you went to Supreme Court, you never said about your loss of this thing.
Lord, that was also brought to the court's notice. The court did not interfere. Lord, kindly permit me to just show, Lord, for a moment.
No, I'm not interested to interfere with this order.
But can I request the court please turn to section 125 for a moment, Lord?
Still. Will order notice to the respondent.
Lord, can I request the court please, Lord? Can I request the court to please, Lord, it's not a question of law, Lord, can it?
It is not at all, can't be appreciated. Every time this is what he is doing. He's only trying to, because he has the capacity to engage the advocates,
No, Lord,
he
it's-
wants to fight it that way.
No,
Not,
Lord, I have paid, Lord, can I request the court to please see, Lord, I have produced a charge. Total, Lord, I have paid about 59 lakhs to her. It's not that I have not paid money. Even, Lord, recently, Lord, I have given another check for 20,000.
how many years? 2012. We are in 2025.
True, Lord. But total that I have paid her is about 59 lakhs.
You will very often, you will travel you are out of country. Your child will be studying medicine and in some
Lord, I have-
broad country. But with 45,000, you are able to do everything.
No, Lord, insofar as, Lord, I have taken multiple loans, I have placed that also on record.
Who is giving you multiple loans of 45,000 rupees income a person has?
No, Lord, what has happened is,
Conveniently, your client is smart enough to not to, whatever the things that can't, like could, all the details were nicely are under the carpet. So whatever that we
no,
can
Lord,
see,
it is not
only
so,
that.
Lord. But even in fact, it's her own case that, Lord, I suffered loss. What happened was, Lord, the property was mortgaged for the, Lord, factory. And, Lord, she was a guarantor. She withdrew her, Lord, guarantee. And then, Lord, the bank issued my securitization notice.
We'll see after.
Lord, can I just
we'll see
request,
after
please turn to,
vacation.
Lord, for a moment, Lord, section 125.3.
Notice to the respondent, petition
Lord.
permitted to serve the hands
Lord,
summons.
can I request, Lord, the interim relief, Lord, insofar as arrest is concerned, Lord. Lord, what she does is, Lord, here, Lord, RPFC, Lord, kindly see the order sheet.
When are you coming up with the NBWs? When is that petition is coming?
Please, Lord.
When is the petition questioning the NBWs is coming? FNWs.
But that order, Lord, was passed, Lord, on 11/9/2025.
So when you come with that, both we will see then.
I'm sorry, Lord.
I think you will come up with that also, that we will see both the orders and what to be retained, what to be stayed, we will stay.
I'm sorry, I didn't get what Lord is
I
saying.
said there are two orders. One is FLW.
No, together, Lord, common order.
Hmm.
Both, Lord, have passed in the common order. That is why, Lord, my submission to my Lord is, Lord, it is legally impermissible. Lord, kindly see, Lord, it is a case where I'm being punished without there being a trial.
Not complying with an order of the court is also not legally permissible.
Lord, can I request, kindly permit me to just pass on not one judgment to the Allahabad High Court, Lord.
There will be
Lord,
101
and-
judgments.
And, Lord, please turn to section 125.3.
Who does not comply with the order of the court
Lord,
doesn't
it's
come.
not-
When was the order passed?
Lord,
In
order
the year
was-
2012.
No, Lord, the order is not passed in
2025.
2012.
Then
Lord, 2012, Lord, interim maintenance I have been paying. Final order that is passed, Lord, by the court is in 2022. I'm sorry, 2023. That is when, Lord, I have challenged before this honorable court, Lord, and this honorable court, Lord, entertained my RPFC. Lord, from
you don't have
2012.
a stay.
Please,
You don't
Lord.
have a stay, entertained, but you have no stay till now.
No, I don't have a stay, Lord. I was not in a position to pay that amount.
Then what
No,
should
Lord.
follow? It has to.
Therefore,
it
Lord,
has
I'm
to-
only requesting, kindly permit me to just show, Lord, section 125.3 for a moment.
I'm aware of what is 127.
When, Lord, if that is so, Lord, I'm only making a request. I'm trying to persuade the court, but I'm aware, Lord, I've seen it multiple times. Lord, for my satisfaction, can I just show 125.3 for a moment, Lord? Because the reason is, Lord, issuance of arrest warrant, Lord, amounts to, Lord, punishing the person without there being, Lord, any trial. Lord, there has to be an inquiry held. But I'm entitled to show, Lord, the court that I'm not in a position to pay this amount. Lord, it is basically civil proceedings. Lord, what the courts have held is, Lord, time and again, you cannot issue, Lord, warrant for the drop of the hat. But if warrant is issued, Lord, there has to be some kind of, Lord, proceedings held insofar as, Lord, an inquiry to be conducted in the matter. It amounts to, Lord, punishing me before, Lord, there being a trial. There is no sentence that is passed. There has to be an inquiry. But can I just persuade, Lord, with one judgment, Lord?
Yes.
Madam.
Yes.
But
But
can
there
I,
is no judgment of the Supreme Court.
please not?
There is no judgment of the Supreme Court.
But there is no judgment of the Supreme Court, not to my end.
So I'm not following this Allahabad High Court judgment.
But can I request the court, then please turn to not the provision for a moment.
Yes.
For my satisfaction, not can I request the court? I'm sorry, not.
This is not the way. It is absolute mockery of the justice delivery system. What your client is doing.
Not my client is paid 59 lakhs, not what he's capable of paying. But please see, not if the court orders not for foreign holidays, not the court has ordered payment of maintenance.
Yes, please read. What is 125?
Not 125, not 3, if not the kind turns to not. If any person so ordered fails without sufficient cost, not therefore there has to be an inquiry to show that I don't have sufficient cost, not to pay, or my inability to pay rather, to comply with the order. Please.
According to you, even if where will this order go?
Please not.
This order of the High Court, where it now the executing court will decide whether this order is right, wrong.
No, Lord, I'm
or
not
you will
saying so.
comply with or not.
For a moment, I'm not saying so.
Then
Not
what
if,
is that?
Not I'll just continue reading this, but I'll answer Lord's query.
Yes.
Can I not permit me to just read it? Not any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of each month's allowance of maintenance or interim maintenance and expenses of proceedings, as the case may be, remaining unpaid after execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made, provided that no warrant shall be issued for recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. But here what she is asking is not from 2012, she is asking for the amount. The court says not more than 3 crores is due. Again, not it's based on the fact that the court says not at this one stage 2,30,000, then 2,80,000 is the order. Now, not in this background, then please then turn to not section 421 for a moment, because not execution not would fall under the arrest not when is to be issued. Section 421. Warrant for levy of fine. But
So
this is
according to you, there is no provision in the act which will make you pay the amount to her.
Lord, I'm saying, Lord, first, Lord, there has to be an inquiry. 2, Lord, the court, Lord, has to issue an order for levy of warrant. That is not FLW, Lord, the court has to issue. In the event, Lord, no recovery is made or no payment is made, then, Lord, arrest warrant can be issued in the sense, Lord, there has to be an inquiry, because, Lord, otherwise it amounts to punishing a person without there being any inquiry. Lord, Article 21, Lord, will be violated. No doubt, Lord, there is an order passed by the court, Lord. I have approached this honorable court, my lords have reserved it for orders. But please see my situation here, Lord. What she does is, but I will show, my lord, from the order sheet. Matters, in fact, Lord, we made a request. I'm not in a position to pay that amount. I had requested the court to hear the matter on merits before the previous bench also. But the court had fixed a date to take up the matter for hearing. But she does not turn up. She goes before the court in Mangalore. Then again, before my lords also, Lord, it happened twice. But she did not argue the matter. Then again, the matter was adjourned. But my difficulty is, Lord, I would request the court to pass final order, Lord, in that matter. Meanwhile, Lord, the executing court is proceeding with the case. But I'm neither there nor here. I'm not in a position to pay the kind of maintenance that is ordered by the court. But I'm not saying that I'm not liable to pay the amount. I'm paying some amount, what is possible.
In the event this petition is allowed
Please.
or dismissed by this court, then what will happen?
But if the petition is allowed, Lord, then
Dismissed.
the petition is dismissed, Lord, then I'll have, Lord, they'll arrest me, Lord, and put me in prison.
Not this, your RPFC.
The RPFC is not gone, Lord, then, Lord, I'll be another case of. Lord, because
your client has his own ways and means to get out of this.
No, it is not ways and means, Lord. But she has filed 75 cases against me. But that is mentioned in the order as well.
You're also coming up with so many cases.
No, this is only second case, Lord. RPFC is filed, after which, Lord, I had filed, Lord, insofar LOC is concerned. Even insofar LOC is concerned, Lord, there was an interim order granted by this court.
I think some amendment to this, all these matrimonial, the laws, that these kind of litigants should be treated in a different way. Either the wife or the husband. The court fee also different court fee. Where it is, if it is 2,000 for somebody, for these people at least 2 lakhs for these people, so that they stop coming to the courts like this. And I know in the jurisdiction, it's a pure abuse of process of law, nothing else.
But this is only the second petition that
No,
is
you know,
filed.
because you have we know what is it is legally, give the file. And ultimately what lies behind it, court can understand.
Lord, I have paid
Where
59.
is the impugned order?
Please, Lord. The impugned order, Lord, said 192,
When
Lord.
the court is vexed up with your client, that's why the court is passing these kind of orders. Earlier also, because that's what you're doing.
But-
The family courts,
Please.
they're vexed up with your client.
Lord, it
That's
is
why
not
they have
so.
no other
Lord,
means to,
Lord,
no other
when-
ways.
Lord, I,
In spite of the fact, the court had gone to the extent of issuing the LOC.
Lord,
Because that's what, because you don't come to the court, you stay out of the country.
no, Lord,
Then what did the court, what the court is supposed to do?
no, Lord, I'm represented by a lawyer. Lord, the party in person, Lord, is appearing
Didn't
there.
represent before the court when you're supposed to represent. That's why I remember imposing 25,000 costs while granting the interim order.
No, Lord, I was present, Lord.
Not you. You means not
No,
you.
I
You
got
means
what
your
Lord- no,
client.
my
Your
client also
client
was
has not
present.
represented when the LOC was issued. When you questioned it, I have suspended the LOC by imposing 25,000 costs on your client, which has to be paid to the respondent. I remember that order.
I'm not very sure about. Lord said granted.
That's sure.
Okay. Lord said granted an interim order subject to payment.
Order,
Yes.
interim order, and while recording that, your client, when the matter was, he has not represented before the court, so I've imposed 25,000 and then granted you a stay.
Lord's memory is much better than mine. Lord.
Not,
I
it's
remember
not
my
a-
Lord said granted an interim order. Lord, I don't recollect that amount of
25,000
25,000.
costs, I do remember, because this is not the way,
Lord,
this is not the way the matters go
I have
on.
given. Lord, I have given her 2 properties. Lord, it's in her name. It's purchased in her name.
Yes, where is the impugned order, page number?
Lord, the operative portion is page 185. Lord, starts at page 182. Let me see the last paragraph, Lord. After considering the aforesaid facts and ratio of the decision, petitioner has made out a case for the respondent is due to for the payment of arrears of for more than 3.67 crores. Learned counsel for the respondent has failed to produce any matter to show the interim order
Please
of
come.
stay.
Agreed with the order dated 11/9/2025, whereby the court has issued arrest warrant and FLW on to the petitioner returnable by 31/10/2025. The petitioner husband is before this court. It is submitted that the court, in clear violation of section 1, the procedure that is contemplated under section 125(3) of the Criminal Procedure Court, has issued these warrants. It is submitted that if an opportunity is given, the petitioner could have could have reduced evidence before the court that he is not in a position to pay the amount. It is submitted that questioning the amount of maintenance that is granted, he has filed RPFC. The same is reserved by this court. Considering the such submission, there shall be stay of all further proceeding pursuant to the order dated 11/9/2025. The petitioner shall take out hand summons to the party in person, to the party, and shall file a memo to that effect by October 15th, or else the stay granted by this court stands vacated. Yes.
Lord, hand summons to her,
Cell
Lord.
number,
Lords have ordered hand summons to her, Lord.
Yes.
Grateful.
cell number 19, Manjunath H for petitioner.
Your Ladyship, for the petitioner father, the impugned order is at page number 18.
18?
18, Your Ladyship. That's annexure A.
Yes.
Perused and heard. I'll read the operative portion, my lords, Your Ladyship. The petitioner is permitted to take the child for celebration of the birthday of the petitioner on 26/9 from 10:30 to 5 p.m. in a hotel or in a public place, and the mother of the child is to be accompanied with the child in the said place. And the next statement, Your Ladyship, the petitioner has to see the safety of the child. This emanates from Your Ladyship's order at page number 71. Because earlier on,
Come to the order.
yes, Your Ladyship, page number 71. Last time, when I succeeded in full interim custody for the birthday of the child, the mother files the petition on 25th afternoon. Your Ladyship takes up the matter at 2:30. And may I read, Your Ladyship? Learned counsel for the petitioner submits that the boy is 3 years old, and immediately after the birth of the child, the father and the mother are staying separately. Considering the boy has no acquaintance with the father and staying with the father from 11 to 8 would be difficult for the boy. This is the false submission, Your Ladyship, because I have all the proof.
Mother is also permitted to accompany the
Yes.
child is the order.
Now
of
what
this
has happened under the garb of this?
What is the age of the boy?
He's 3 years, 2 months. So tomorrow is the father's birthday and he wants to celebrate birthday in his house with his grandparents and all the fraternity and people from, but we have been asked to go out because of this order. And Your Ladyship, you further directed her to give us a hand copy of this. That has also not been complied. In fact, I came to know this because the order was released on 20th. We applied for certified copies. Then we are aware of this petition as long as they brought it in their objections. The more important situation, Your Ladyship, is this is perverse to your own orders, most importantly, for the Dasera vacation. It has not been considered only when I had succeeded in interim custody yet.
So what is that you want?
I want a simple modification like it has happened last time. Tomorrow, please allow me to spend my birthday with the child, with my family, unless what has been stated, which is outside.
Learn counsel for the petitioner is permitted to take out hand summons on the counsel appearing for the respondent.
Yes.
And shall file my memo to that effect. List this matter tomorrow.
Highly obliged. Can this order be uploaded, my lords? Because they will not accept service otherwise. If this order is uploaded, it makes my work easy.
It will be up. Every order is uploaded every day.
Yes. Highly obliged.
Cell number 20, preliminary hearing of Eshu Baba Mishra for petitioner.
Yes, I appear for the respondent. In this matter, my lord has directed me to pay maintenance as ordered by the court, and my lord also permitted me to have visitation. I am giving a demand of 6 lakh rupees. The arrears I will make good in another 2-3 weeks.
What are the arrears?
8 weeks time has been granted. It is within time.
Yes. What are the arrears?
Over a demand of rupees 6 lakhs in the name of the respondent. Lord, one request, Lord. It is
No. What are the arrears? 6 lakhs you're paying.
another, my lord, maybe 5.5 lakhs or something. What?
That you will be paying within?
I'll pay within time granted by
As
the
per the impugned order. I mean,
within
interim
8
order.
weeks, my lord has ordered.
Within 8 weeks, my lord, the earlier order matter within 8 weeks.
Oh.
That has been not completed after 2 months. Yes.
So ultimately client has to get money. Yes. 5.5 within another how many days are left?
3
from
to
now
4
onwards?
weeks. 3 to 4 weeks.
Yes. When is that order? Let me see.
Balance is 6.5.
That's what is. How much is balance?
6.5 lakhs.
Whatever is the balance.
Whatever is the balance, I pay.
So within a period of arrears of an amount that is within a period of 8 weeks. This order is passed on 24/7. Almost it's over.
I'll pay, my lord. Another
Yesterday
2-3 weeks, my lord.
That's what. Finally, we'll fix a time. That's why I'm asking you.
Very well, my lord. My lord may fix any time, I'll pay.
So the remaining arrears have to be paid by.
An outer limit of 4 weeks, my lord.
No. By 14th of October.
Please.
One request, my lord.
That is one. Next.
My lord has granted visitation after many years. My client has seen his son over 8-9 years. But my lord, they have not been complying with the order as passed by this honorable court. Only once my client has.
What is the order? Please come to the order. The father can exercise the visitation at a nearby mall on every Saturday and Sunday between 3 p.m. to 6 p.m. And with regard to the place in the mall, the father shall communicate with the mother. Yes, what is happening?
My lord, more or less, my lord, I have been requesting, there have been no responses. I have been sending emails, I have been sending
You have not
messages.
met.
Twice they have met, my lord, in all these days in 8 weeks.
like I passed order on 24/7.
Yes, my lord.
Then 24/8, almost 24/9. So these 2 months, at least how
On
many?
2 occasions they have.
Yes, my lord. Last Saturday, my lord, he has spent about 6 to 7 hours with his father.
Is it correct?
Yes.
And
That's-
what about the other Saturdays and
What
Sundays?
happened, my lord, when he has visited on the first day, my lord, he has stopped going for a mall, my lord. Your worship has directed to go any mall, my lord. He has stopped going for the mall, my lord. I don't come to any malls, but what he's saying, he's before the court, my lord.
Where he wants to go?
Anywhere, my lord, but he doesn't want to cope up with his father, my lord. His attitude, my lord. Lordship, kindly go, I'm ready to send him in the in-camera proceedings, my lord. Lordship, kindly ask. We will not come anyway, my lord. He psychologically so upset, my
No,
lord.
my lord, I am sorry, my lord. I have videos of the last meeting. He has enjoyed this thing. He has spent 8 hours, like my learned friend himself says, spent 8 hours with his father. That may not be correct. He is being forced. My lords may kindly see, the father-in-law comes. He has, and they have assaulted my client years ago. That is why my client has kept away. My client, even today, after such long separation, has been trying for a reconciliation or at least some access to the child. There is a video, my lord, I have a grab of my client being assaulted. We have produced it before the trial court, but at the same time, Lord, today, last development on the last date of visitation is positive. But now that they are saying that he is scared and all, that may not be correct. The child, my, my lord, the child has not had touch with the father for years, and he has spent a good time last week. And that is because my lord's orders, but they are not following it. If they follow it, my lord, the child will have a better
Why
response
he
to
is
the
doing
father.
like that?
Please.
Why he is doing like that, the child? Continuously he is,
Lord, he has,
his hands.
my lord, he's become psychologically uncomfortable after meeting his father, my lord. Psychologically and mentally, he has been hospitalized for 2 days, my lord. He has become totally, my
that's
lord,
a-
he has hospitalized.
The blatant lie, my lord.
I'm sorry, my
Lord,
lord, we are not
I
killing him.
have
My lord,
videos and photographs.
I will show only one video, my lord. Small video, my lord, which has been taken on Saturday, my lord.
Then what were they doing for 8 hours together? If that is the case.
Only short video, my lord. 2 minutes. How he behaves with the father, my lord.
What is this? I'm not able to understand.
My lord, he is scaring to see his father, my lord.
Why, what happened?
Lord, we have sent.
Father saw him first, last.
Please, my lord.
When did the father meet the child on the last occasion?
Saturday, my lord. Last Saturday.
Before this order is
Before, my
passed.
lord, on 24, next, immediately we went.
No, before this order is passed. When did he meet him?
3rd December 2017, my lord.
2017. What has happened on December 2017?
My lord, the father has been assaulted to the mother, my lord. That he has seen, my lord. Even the child, my lord. That he has seen, my lord. From that day, he is scared to see his father, my lord. And he has been thrown, mother and son has been thrown out, my lord, from the house.
The mother should do something to get him out of that. She should take him for any therapy that is required.
My lord, that's why,
And
my
by
lord.
keeping quiet and saying that
My
the
lord,
father,
my lord,
by saying that the son is not interested to see the father, that's not the solution.
No, my lord. Absolutely, we are not denying anything.
Father has to do something.
Yes, ma'am. We are doing.
And from 2017 till now,
Yes,
it's
ma'am.
already 7 years has passed by.
He has not seen, my lord. He has not no
What I'm
communication.
saying, after 7 years also, why is he remembering it? If he's remembering, that is something is not right.
Yes. I have seen last matter, my lord. What you are passed an order, my lord.
That's not right. I think what is happening is all these parents where
Yes,
there are
please.
disputes, they're okay with this kind of mindset of the boy, if he's behaving like that. That's not for in his
But
interest.
he has become psychologically upset, my lord, after seeing his father. I'm extremely sorry, my lord. We don't want to express this, my lord. He doesn't want to see, my lord. He went in the nice road. Two hours, my lord. He has taken his father in the nice road, my lord. He has very much upset in the car, my lord. I don't want to produce all the things, my lord. He is very much upset. I wanted to go home. He is telling that I wanted to go home. I don't want to go anywhere.
He's otherwise normal.
He is normal, my lord.
My lord,
After seeing his,
Appears so.
I request, my lord, that
He
a
has some
psychological
issues, I think.
assessment be done by the
Has
order
to
of
be
the
done.
court.
He has to be taken to the NIMHANS or any other
yes, my lord.
doctor.
I will suggest.
I will direct tell go to the mediation, Bangalore Mediation Center.
Yes.
The therapist
The
is
mediation
available.
already it has been honorable court, my lord. The mediation is going on, my lord.
Not mediation for his assessment
Yes.
at the mediation center. It has to be.
Yes,
You're not. That is not as simple as you're
Yes,
submitting.
yes.
He's otherwise also not appears to be not normal.
Yes.
Let there be an assessment
Yes.
and let
You
something
can.
be done to him.
Yes, please. That's why, my lord, I brought him. Otherwise, I would not.
Lord, they have not revealed any of this to me. In 7 years, my lord, I have not been able to have a look at him. My lord, his Brahmopadesha, my lord, the father has to do it. They have not informed my client.
But we have sent an invitation.
That's not no.
No, my lord. We
They
promote.
can't send an invite, my lord.
No,
It is
no.
the father's
Please
program.
listen
we
to
have-
the court.
We
They
have
are
asked.
nobody to conduct it.
We have asked him to come, my lord. He has
No,
not turned up,
please
my lord.
listen to the court. You being present from his whatever ritual you're saying, that is not the point.
No, my lord, I have
No,
been
that's
trying.
not the point now.
All
Whether
my-
you're there or not, his well-being is more important,
No, my lord,
which appears that he is not. So it's now, please stop arguing on the merits and on making allegations against each other. First see what is to be done to him to make him all right.
I'm ready, my
That
lord.
is
I am
that is what is
requesting for a
required at this point
psychological
of
assessment
time.
of the child. I am
It
myself,
can be
sir.
done. We are not objecting. Absolutely, we are not objecting.
And they have hidden all of this from me.
He can't speak.
He can. He can speak. He is telling that, but I will come to the court and inform to the court, my lord. What is he telling before the mother?
In which school he is studying? Which class you are? You're in 8th class. I'll ask him to come to the chambers around 2:30. Please keep. 2:30 or 2:50. Yes. $2.15 in the chambers.
215 in chamber.
Yes, next.
Serial number 21. Serial number 21. Arun Govindraj for petitioner.
For the respondent, your lordship.
This matter was posted from yesterday to today for me to clarify one of the expenses pertaining to Sukanya Samriddhi. Prior to that, if I may be permitted to justify as to why adverse inference is to be drawn in
No,
this.
let's not go to that. First of all, you clarify what is that?
Page number 36, your ladyship. I clarified with my client, was informed that when the parties were cohabiting, there was a recurring deposit in the name of the first petitioner wife of rupees 13,000 every month that was deposited by the respondent.
Why did she show it in her monthly expenses?
Subsequently, that had stopped towards investment.
So she's not paying it. So
She's not paying.
So
that
67,000 minus 18,000.
That comes to 49, your ladyship.
Yes, 49,000. So how much he is paying now?
Nothing. I have received not a single rupee since the date of filing.
From his also, you have told another 25,000, which is not your monthly expenses, Mr. Counsel.
Your lordship.
You have also shown 25,000 rupees.
25,500, I clarified, your lordship. That is
a monthly expense, it's a yearly expense.
no. That's a monthly expense because it is towards the term insurance plan for the pension.
Term insurance
3 lakhs is annually it is being paid. Monthly it will come up to 25,000 rupees.
What is the wife doing?
She's working as a primary grade facilitator, Your Ladyship,
And-
in a school. Her
What's her
salary
salary?
is 18,000. Yesterday, I erroneously submitted 20. I brought her latest salary slip, if I may place the same.
Yes,
In
20,000.
hand, she receives about 18,745, Your Ladyship. I'll furnish a copy to you.
And for a moment, if your lordship can look into page number 42 of the petition.
Yes,
Page number 42 of the petition. It is the assets and liabilities what they have filed before the court.
yes,
Page number 42, para number 8,
yes.
fixed deposit account. That is the account number with HDFC Bank and PPF account. And they have furnished the assets and liabilities, also the endorsements in respect to that fixed deposits. Fixed deposits in respect of HDFC is 2,20,459 and 3,17,052 is in respect of the second account. And apart from that, if your lordship can look into the joint account, page number 43, the 1,07,252 as on 26/9. 28/9 was the petition being filed. And earlier to this is the statement. Totally, it comes up to 2. With SBI, FD is 2.2 plus 3,17,052 and the SBI 1,07,000, 6,44,763 is the total amount.
Hmm.
That in the mediation, when the matter is posted before the mediation, she considered that it has been withdrawn. This entire amount has been deposited into her account. Close to 6,44,763 has been withdrawn. And now they utter before this particular court saying that not even a rupee is paid.
Pursuant to the order, not a rupee has been paid, Your Ladyship.
Did you reveal this fact that you have withdrawn this amount?
Your Ladyship, this was filed in 2022. At that time, the amounts that were there in the account has been withdrawn when the affidavit of assets and liabilities was filed. It was filed along with the petition. The statements are as per the balance 2 days prior to filing, Your Ladyship.
So, that is, at least per year, it would be 53,563 per month, if it is.
It is not entirely his money. That is to be justified. It is not entirely
Working,
his.
then
I'm not.
It was not working at that point in time, your lordship.
I have
She
received money even
admitted.
from my family earlier. I have a brother.
Yes,
Right now, I'm surviving on the money given by my brother.
During the mediation, they themselves
I will
considered
justify
we have
the same.
utilized it. And now they are taking it a different stand, your lordship.
Clarify one aspect, whether that amount which is deposited or which is utilized by them is contributed by you alone or by her also.
There is a bank statement which herself she has submitted.
In that it is
Yeah.
there. Let's see.
Like assets and liabilities,
Hmm. Is it filed before this court?
it is assets and liabilities is before the
Assets
trial
and
court.
liabilities are not filed before this court.
The mark portion. 3 lakhs FD is being paid from my account.
This is matter after vacation.
Ladyship, may both parties be directed to file their affidavit of assets and liabilities.
Both the parties
reason
will file their statement of assets and liabilities before this court.
Great.
This is matter after vacation. Next 23.
Much obliged.
Till number 22 urgent, 23,
Fine.
we are Balraj, Mentor Isaac for respondent.
number. It is mine, your lordship.
Was this for serial number 24, my lord?
23, it is ours.
Ravi A. Belgavi.
23. Lordship, in this case,
Family court order is complied with or not?
My lord, on second Saturday of August and fourth Saturday of August and on second Saturday of this month, petitioner had brought the children to High Court, my lord. Respondent did not turn up and did not pick up. On 22nd, respondent had sent a message on WhatsApp. He had come here. I also have
Lordship.
photographs, my lord.
June,
July, August and September, second Saturday, our phone number is blocked.
5/8/2025.
5/8, yes, my lord. After that order,
Passed an order.
Yes, Your Honor.
5/8/2025, this court has passed an order.
Passed an order.
Petitioner father had questioned the order passed by the family court dated 12/12/2025, whereby the visitation is granted to the mother. If the father wants any modification of this order, even to consider the plea of the father, first of all, the order that is passed by the family court has to be complied with. List this matter on 25/9/2025. Till such time, the order passed by the family court has to be complied with. What happened to that order?
Your Lordship, therefore, Your Lordship, earlier, the summer vacation, they have given a custody of the children to us. Thereafterwards,
I'm asking you 5/8/2025, after that, what has happened?
they have not given custody of the children to me, Your Lordship. And also, my number is blocked. They have not at all pick up our call. And also, there is no information to the wife. To last date of hearing, Your Lordship, this Honorable Court directed them to High Court, the legal authority, where you have to take the children from there, that place, Your Lordship. That was also not complied.
we had come, my lord. I have produced photographs.
Your Lordship, they have not even called us.
Why should they call you when there is an order? Are you not supposed to come to the place?
We came, Your Lordship. We
22nd.
came last three occasions, we came, Your Lordship. They didn't give to us. What is here?
My lord.
Call today, give it to them. We'll take it up this matter at 4 o'clock. Let the mother meet the children. We'll
Please,
make it up at 4 o'clock.
Much.
Just list this matter, call this matter at 4 o'clock. In the meantime, the mother can exercise the registration. Yes, next.
Number 24.
Yes, next.
24. We are Balraj Minto Isaac.
Represent the petitioner. You are
Respondent.
directed to file, my lord, a memo of calculations. Petitioner is. Husband.
What about you?
I've already filed before,
When?
in the filing counter on day before yesterday, madam. Already filing counter I have filed.
Have you seen this? Look at it. Look
Yeah,
at
I have received.
So
the-
he's spending 40,000
Now,
towards the
my lord,
family.
present writ petition is filed only in so far as, my lord, direction issued by the family court with regard to the EMI, my lord, 50% EMI, wherein, my lord, husband was directed to pay. Other maintenance and all order and all those things, my lord, husband is complying with, the wife has not challenged.
You have included in the expenses that monthly EMI of Kodagu property.
My lord, Kudlu proper.
Oh, it says Kodagu.
Kodagu.
My lord, that included, but here direction we have challenged is, my lord, pay 36 months.
But that is which property?
That is different property, my
Which
lord.
now the court has asked you to pay.
No, my lord.
Court has directed to pay only Kudlu's property.
Huh?
Kudlu.
That is another property.
Yes. Kindly see the, my lord, page number 36 in the writ petition, my lord.
So with all this, it's coming to 1,76,000.
My lord, other so far as maintenance is concerned, my lord, there is no dispute.
No. So what is the salary of the husband?
My lord, one submission, my lord. So far as, kindly see, my lord, page 35.
No, before that, what is the salary of the husband?
Salary, my lord, I have filed assets and liabilities, my lord. Annexure 151, my lord, page 151.
What is the salary?
Total 1,61,000.
1 lakh?
61,000.
What is the gross salary?
2,49,000. Mentioned at page number 151.
Kindly see, my lord, page number 36, may I draw your lordship's kind attention.
Yes.
35.
Yes.
IA number 3 filed under section 24 read with section 26 of Hindu Marriage Act.
read with section 151 of CPC is partly allowed. The minor children and of the respondent are entitled to maintenance of rupees 40,000 per month, which includes educational and extracurricular expenses from the date of the application. That maintenance amount I am depositing, that is not challenged. Kudlu house, what is the EMI?
Currently
41,000
44,000 per month. Currently 44,000 per month.
What is your income? And she is getting rent of rupees 28,000, page 162. From that property? From the, one of the portion is. Where is that? Page 162, man. The assets and liabilities. Serial number 8, 162. By rent rupees 28,000 per month from March 2023 from the joint property of party, a house at Kudlu, Bangalore, which is being used for the payment of EMI. Your income apart from this?
Sorry, my lord.
What is your income?
My current income in 2023, as per my assets and liabilities, it is 1,50,000. And my lord, I want to know the expenses, what they have quoted. First thing, they have quoted the September 2023 salary. They are quoting 2,49,000. And expenses they have quoted is of 2025. So they should take the salary as a base of 2025 when they are quoting the expenses of 2025. So even if we see his memo of calculation.
No, already for one joint property, husband is already paying.
Sorry.
One is at Kodagu.
That Kodagu property is not a joint property. Kudlu property is a joint property.
But he says so.
He says IDBI loan monthly EMI at IDBI bank. Currently, what bank?
Monthly EMI at IDBI bank taken for the construction of Kodagu property now stands in the name of respondent means?
No, it's not in name
in the name of respondent's father. He contends that he has also invested. Now question is only with regard to the EMI I have challenged. So far as grant of maintenance is concerned, my lord, I have been paying. Wife has not challenged it. EMI, my lord, 50%. There is a direction to pay 50%, my lord. Out of that, 28,000 rent may be deducted, and remaining amount, my lord, I am ready to pay 50%.
Now, my lord, this EMI which he is saying of Kodagu property is nowhere related to the current EMI which is challenged by them. That is of
Let us
Kudlu
leave that.
property
Let us
which
leave.
is having the in the joint ownership of both the parties.
But that joint ownership also he is only paying.
No, that is a false statement, my lord. I have full. If my lord takes annexure F.
Don't have to. You can tell the facts, sir. What is that you're paying?
So every month she is transferring 30,500 to the Mr. Raghavan's Citibank account, and then 41,509 he was paying to the SBI bank loan account. There is a transaction already shown in his annexure F. Now, what has happened is he left in October 22. From February 23, he stopped paying. So to protect the Kudlu property, I started paying entire full EMI to the bank. So which was 52,000. I admit that I have overdraft, taken the facility of overdraft of 2,50,000. But prior to me, he has taken the overdraft facility of 31,12,000. So the interest of that is also been calculated in the current EMI, quantum of EMI. So I am burdened with the paying of the what overdraft facility he has taken from the March 22 and what overdraft facility I have taken of 2,50,000. That also had taken it on the because of the urgency of medical requirement of my son. I need for the operation. He had suddenly left with no income with me. I was earning at that point of time 1,25,000 or something monthly income. Then I have changed the company, and from that in 23 I was earning 1,50,000. I have given that details in my assets and liabilities, my lord. And my lord, as far as his income is concerned, in somewhere in the year 22, in his annexure F, it shows that his income is 3 lakh at that point of time. And in this, he is showing the gross salary. That is, whatever will be deposited in our account will be the net salary. And the gross salary, after deduction only, they will transfer it to our account. Now, when his net salary is showing 3 lakhs, in 23, he is showing as 2,49,000 is somewhat suspicious. He has not brought salary slip before the honorable lordship. But somewhere in the assets and liability, he is also showing that his income, in form 16, it is already shown that his income is around about 3 lakhs. So presently there will be in 23, if we are considering 2,49,000, there will be some increment in the income. I want to know what is the current income compared to expenses he is providing.
The petitioner
My
should
lord,
place
I
before
have
this-
given the expenses of the children,
Petitioner
which
shall-
amounts to 1,33,000 per
petitioner
month.
shall place before this court his salary slip, right? His salary right from the date the application is filed till now.
But a respondent also can
The respondent also shall place the salary slips of the respondent from the date of petition till now. Yes.
No,
after
one,
vacation.
to minimize the litigation, in the absence of any prayer for grant of EMI loan account, no, part of the loan account, my lord, then a trial judge has granted.
But-
There is no application.
No, that is not there. Then if the same amount, if the court grants by way of maintenance, it will also be equal. Yes, next.
Cell number 25, Mahesh BJ for petitioner, Dinakar NP for respondent.
There is other side. Interim order is there.
Yes.
This is matter after vacation, no representation of the respondent. Interim order only granted is extended till then. Yes, next.
Cell number 26,
For the respondent, please.
Anshuman.
There's also counter writ petition that's been filed. For the respondent husband in this matter. I've also challenged the interim order that's been passed. And the FR number, please, Manoj, is 29875
It's
2025.
not FR number, we want a writ petition number.
But it's been filed, it's under scrutiny. So
Your interim order in your case,
there's no.
There's no interim order so far, my lord.
you're for the wife.
Yes, ma'am.
This is matter after vacation.
At least interim order may be given.
No interim order. In these matters,
My lord,
we will
he's,
hear-
Thai
application is dismissed, we will hear it only finally, not in between. Yes, next.
Cell number
My lord,
27.
one second, one submission. My lord, if 6-year-old children are kept away from the mother, he has absconded from the house. He's not showing the children to her. Then what is the
What is
prejudice?
IA? What is order?
Custody, my lord.
No, Manoj. It's for interim. Manoj, there was an application filed for custody. The application was rejected. Interim order was, application is filed seeking custody. While dismissing the IA, visitation rights was granted to her.
Then what is to be done?
No,
No,
visitation, no, he is not exercising any visitation rights. He is
My lord.
run away.
We
My lord,
file execution for that.
my lord, we'll
File
file
contempt
execution.
for
My lord, filing execution is one thing. We don't even know where he is.
Manoj,
Where are the children?
Manoj, may I make a submission, Manoj?
No, where are the children?
Children are with the father. What has happened is,
Tomorrow?
Manoj,
Father shall
Manoj,
get
it
the
may be
children before-
along with my writ petition,
No,
please.
no. First of all, let the children come to the court. This is matter tomorrow.
Please.
At the time the father shall shall be present before the court along with the children. Yes, next.
Cell number 27, adjourn 28. Cell number 28.
27.
Somebody has mentioned, I think. What is that?
Just a 2-year, 2-month-old child was given to the father.
Morning, they have mentioned that. Look at it, that they have informed to the other side and sought for who is that? List this matter tomorrow. You are appearing for the?
Petitioner.
The list is matter tomorrow. Morning, a mention is made by the respondent stating that it is informed to the counsel for the petitioner. The counsel for the petitioner and the matter is called submits that it is not informed. List is matter tomorrow.
Cell number 28.
Appearing for the respondent, my lord.
Gankadharaya.
There's an interim order by this honorable court. However, that same has not been complied by the petitioner.
When is the order?
Not page number 43, my lord, it
No,
commences
no,
on page
when is the interim order granted?
28,
It is on
2025.
28, 2025.
Please, my lord.
And 8 weeks time is granted. Where is your question of non-compliance?
Payment of 9,000 rupees per month.
That would come
September
by 5th of every succeeding month.
5th of September
This
has
month.
passed by, my lord.
This
Sir,
court
despite
has
that-
passed an order on 28/9/2025. There is no representation on behalf of the petitioner. Then comes for the respondent submits that there was a direction to pay an amount of rupees, how much?
9,000 rupees.
9,000 rupees by
9,000.
5th of every succeeding month. It is submitted that it is not paid. It is made clear that if the amount is not paid by Monday, the stay granted by this court stands vacated. That is the 9,000 and the arrears also, if they are not paid within the time, the stay granted by this court stands vacated and the respondent is at liberty to execute the matter, execute the order.
But bank account details has already been given to the petitioner as directed by the family.
Still number 29.
Grateful, my lord.
Petitioner, kindly pass over.
Pass over.
Still number 30.
29, maybe shown wrongly,
Oh, yes.
different case.
Huh?
My name has to be shown.
Yeah, put up wrong.
Yes, my lord.
It should be what? Then counsel for the petitioner submits that the wrong wakalat is wrongly put up. The registry is directed to rectify the mistake.
My friend is present.
I'm on.
This is a matter after vacation? After vacation, yes, 30.
Still number 30.
This will be directed to the.
And delete.
Already I have said so, yes.
Lord,
Till number
this
30.
matter was listed on 15 and your lordship are pleased to issue notice, my lord, and also to serve a copy. I had served, my lord, my learned friend has entered appearance. It's a case, my
Just
lord,
seeking password.
pass over.
Yes, next.
This is number 30 minutes.
30. Pass over is
Huh?
29.
He is representing 29 minutes.
29 is adjourned after vacation. What about
29 after vacation. Now it is not come to locality. Now 30 I called.
Yes, 30 who appears?
I appear.
Because that wrong wakalat is put up, that's not belonging to this case.
29.
Yes,
Still
30.
number 30.
30 my lords, the urgency is, matter is posted for arguments on Saturday, my lords.
We'll pass over, inform the council. If he doesn't
Yes.
turn up in the afternoon, we'll pass the order.
Yes.
Yes.
Oblige.
Yes. Still number 31. Parted.
Let's file the NOC wakalat in the earlier date, my lords. Kindly,
That day you ask for time.
I need to prepare and get the instructions, my lords.
Not required. Not required.
My lords, kindly please, my lords, I don't have any instruction. I'll get prepared, my lords.
On your
It may be
on
in the
your
same caption, my
request,
lords.
the matter is posted
My
to
lords, on
today.
the same caption
Please
only, my
don't, it will not be there. Either you argue or I'll hear the petitioner counsel and pass orders. Pass over.
My lords, at
32.
least can it tomorrow, my lords.
No, court has no time tomorrow. Yes, 32.
Documents has to be professional, my lords. Kindly please.
Not required. Yes, 32, Pratima.
Much.
Pass over, ma'am.
Yes.
Still number 33.
My lords, appearing for the,
Nishant Nand.
appearing for the
Ask for a
petitioners, my
passover,
lords.
it is not a,
He will come, ma'am.
don't
Lords, I'm seeking for a short adjournment, my lord, solely
let the
because,
advocate come, pass over.
my lords, the advocate, other side advocate is here, my lord.
Yes. What is this party coming and
My lords, it's not
that is previous
part
one.
of this
That
case.
is
yes,
32.
33.
33.
My lords, I'm only seeking an adjournment because of the same bereavement that I had mentioned earlier. There are some rituals. My senior is unable to come.
Yes, after vacation.
Still number
My lords, interim order may be extended, my lords.
Interim order is extended. 34.
Still number 34.
Oblige, my lords, deeply.
K. Ravi Shankar.
This also pass over. Same advocate in the other matter also is appearing 30 also. Yes, 35.
Still number 35 is at 2 p.m. in table.
How many passwords are there?
There are 4 to 5 passovers, sir.
Yes.
My apologies, Lord. Can I seek one indulgence, Lord? In seal number 18, Lord, I've ordered hand summons. Lord, instead of hand summons, can I send it by email? Because she's in Mumbai. Lord, I don't want another criminal case to
Issue emergent notice in that case. Yes.
be.
Will issue emergent notice.
Very well. The
Yes.
interim order will be there.
Yes.
Please, grateful.
Issue emergency notice, sir. ನಿಮ್ಗೆ ಆಗಿದೆ.
ಮೇಡಮ್ ಯಾವ 13 ಕಾಲ್ಔಟ್ ಆಗಿದ್ದು 30 ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ಈ ಕಾಲ್ಔಟ್ ಆಗಿದೆ 34 ಅವ್ರಿಗೆ ಆಯ್ತಾ ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ 30 ಏನಾಗಿದೆ
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲ ರೀಚ್ ಆಗ್ಬಿಡುತ್ತೆ
34
ಇದು ಬೇಗ ಆಗ್ಬಿಡುತ್ತೆ
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ
ಏನಂತ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಏನಾಯ್ತು ಮೇಡಮ್?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಇನ್ನು ಕಾಲ್ ಔಟೇ ಮಾಡಿಲ್ಲ ಸರ್ ನಾವು.
ಓಕೆ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಡೇಟ್ ಅದೇ ನೀವು ತಗೊಂಡು
ಹೆಸರು ಅಸ್ಪಕ್ ಅಂತ
ಜಾಯ್ನ್ ಆಗಿ ಏನು ಇಲ್ಲ ಇಷ್ಟೇ ಇದೆ.
ನಾನು ವಿ ಓನ್ಲಿ ಅಷ್ಟೇ, ನಮ್ದು ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ. ರಿಜಿಸ್ಟರ್ ಆದ್ರೆ ಅದಾಗ ನೋಡಿ ಮಾತಾಡಿ.
Court officer?
Password.
Appear for the respondent.
Yes.
I have 3 submissions to make. I just received this copy. This is an affidavit, my lords, which is sworn in the month of February 2025. This is assets and liabilities, wherein, my lords, it has clearly mentioned that 25,000 per month, which has been ordered in criminal misdemeanors, and 10,000, which has been ordered in this honorable court. As on February 2025, my lords, 16,75,000 has been paid to the petitioner, and 4
if
lakhs.
you have paid, show it. Where is the account? When she's placing the account before the court,
Please, my
to
lords.
which you are transferring, where the 10,000 do not find place, why should the court take that
What-
admission into record?
Now, what has happened in this case, my lords? Separate 10,000 rupees, my lords, has not been paid, because always whatever the payments will be done, my lords.
When the court says 10,000 payment is 10,000.
So, my lords,
In your morning one order I have passed, allowed.
I have 2 more submissions to make in this matter, my lords. One submission.
That you said you are going to forego that. That you are going to forego. Yes, 65,000 morning order as it
Lords,
is allowed.
one submission in this matter I have to make, my lords. At the time of passing of the impugned order, my lords, there was no assets and liabilities filed by both the parties before the trial court. Thereafter, subsequently, in the month of February, there's an assets and liabilities filed, wherein, my lords, this clearly states, which he is also employed, she is also in, and in fact, the loans jointly taken together and all those liabilities has been categorically explained. What I request before this honorable court is, this was not filed before passing of the order. The
Why you not file?
No, my lords, this is a case which is filed in the year 2018. The trial court did not insist to
file the assets and liabilities at that point of time. So it was not filed. Now, my lords, however, it is filed. But this order is prior to that. What I request is, my lords, the application can be reconsidered in respect to the contentions put forth in this assets and liabilities. Because, my lords, he is earning.
It have been done, provided your client was behaving like a normal litigant.
My lords, he has paid 16 lakhs. He has sworn to in the affidavit itself, my lords.
Why was the
Now-
court adjourning the matters? Why was there was no complaints? The causes system says non-filing of acknowledgement for having paid rupees 10,000. Your client is taking the court orders very casually.
No, in fact,
which
my
is
lords,
not permissible.
now, my lords, he stays in Singapore. Now I had a call.
Let him stay like,
I had a call with
on
him.
the
my lord.
planet.
No, my
we are
lords.
we are not bothered.
No,
about
I
it.
did not have an easily accessible to him. Now I had a call.
That's his problem.
Now I had a
If
call.
he's not accessible to the advocate, that is his problem.
No, my lords.
He'll be buying. He'll pay for it.
No, my lords. Upon the instructions from him, I had a call with him, my lords. His submission is, my lords, if the 10,000 has to be paid separately. Right now, my lords, if the learned counsel will tell any account number or anything, my lords, right now he will be separately sending the 10,000 rupees.
So, according to you and your client, the order that is judicial order is not sufficient.
No, not like that, my lords, because it is a lump sum payment which have been being made to the plaintiffs, like 3 lakhs, it is 2 lakhs, it is 50,000. In fact, it is stated in this. In February itself, this is sworn. Now I have received the copy from Mangalore. My lords, just have a look at this, my lords, once.
It's not convincing.
This is an asset which has been.
Court has so many cases. It will not spend time on the party who has no respect to the orders of the court, who do
Lords,
not pursue the litigation in the manner that is required to.
it is a sincere apologies, my lords, but he is earning 6,500. In fact, my lords, there is a joint house in Singapore in the name of the petitioner and the respondent. 80% stakes is in the petitioner. He has been requesting the petitioner to come and sign the papers so that it can be disposed of. Half of the problems will be solved with respect to monetary aspects.
For all this conduct, another 25,000 to be paid. I'll hear it after vacation. Or else I'll confirm whatever is the order that is passed. For wasting all the time from morning, I spent 20 minutes to dictate the order. And again, another 10 minutes now. I'll say 25,000 again costs. On that, I'll recall that order that is passed in the morning.
The nominal cost may be imposed and then adjourned after 8th or 9th. my lords. It is my humble, because there is a lot of things which I'll have to place it on record.
After the order is dictated, then counsel for the respondent comes to appear before the court and submits that he was engaged in the other court. When the court asked him about payment of 10,000, which is even as per the cause list also indicates that acknowledgement is not filed. It is submitted that the amount is paid, and according to the petitioner, the amount is not paid. It is submitted that along with the other amounts, he has paid this amount. As such, the amount of 10,000 that is deposited is not found as per the bank statements filed by the wife. When the court has passed a specific order, it is a duty of the respondent to comply with the order and also to file a memo in that regard saying that order of the court is complied with. But the respondent very casually taking the orders of the court. However, considering the submission of the respondent and also balancing the interest of both the parties, the order the order that is dictated in the morning is recalled, and the respondent shall pay an amount of rupees 10,000 for wasting the court's time to the petitioner wife. This is matter after vacation. Yes.
Serial number.
I'm asked, morning also I asked you, why is it an executing court? Why can't you file an AEP? Already there is an order. He is not complying with it. What is another order from this court? Yes.
Serial number.
Will not pass any of that.
Serial
kind of
number
order.
6, Girish B.
Yes.
Baldare, for
Which is
petitioner.
that?
6,
Yes.
For respondent, Your Honor.
Bilal Ahmed. Ready?
Take that.
The WhatsApp taken to the custody of the petitioner. So the order passed in the gate of PC. This is page number 2, my.
Page number
2.
Hmm.
So I accepted the grounds memo and I accepted and accordingly both the wards are handed over to the custody of the prisoner for the director's admission. Totally now 9,000 is awarded, 3,000 each went. For the two minor children and wife, 3,000 each is awarded by the TV Act. So I write the memo also before the
There is a memo?
legal petition. Page number 4.
Yes.
Except 2-3 months to I have paid the entire amount. And in the recently month of
Your Honor,
page number 6 I can read. In the month of August I paid the 10,000. And for the reason why I not paid the installment, because I have prepared my reason petition against the other person in the domestic violence act. Here in the session court notice has been issued.
Please come. Have you taken this order and give it to the RNS? Agreed with the order passed in.
Your Honor, the income of the petitioner has not been
I'm not
revealed.
going into all that now. I'm not going into all that.
Page number 44 it will not.
Agreed with the orders passed in. I number 1. What I number 1?
Page number 3 ma'am.
I number
3, page number 20, I number 3. The 24 of the income marriage.
No, if the order is cancelled, then for living of
I'll ask him to cut till the pendency of that application, whatever is the interim order, that to comply with. Where is that? I'm not able to find the order.
Page number 44.
Have you given this order? Not that. That's why I was telling you.
Entire order sheet I have sent. Whole.
From clear. Why do you want all that? I said only this order. It doesn't make any sense. It is only this order. You can tell him that. Yes. Agreed with orders passed 9 number 3 in MC number 111 of 2022 dated 13/1/2025. 13/1/2025. The husband is before this court. The court were ordered, 16/12/2024.
Then again it's postponed 13.
Dated 16/12/2024. The husband is before this court and counsel appearing for the husband submits the court with considering with any of the facts and the assets and liabilities that are filed. Have you filed the assets and liabilities? The court had passed an order whereby an amount of rupees 8,000 is granted by the court as maintenance. Then counsel it is submitted that the court has failed to consider the law laid down by the apex court in Rashish versus Neha. Next parallel, counsel appearing for the respondent submits that the court had considered the facts and granted the maintenance and no interference is called for. Next para, having heard so and so. In spite of repeated orders passed by this court and the directions that are issued on judicial side and the administrative side, this court is not able to understand why the courts are not following the law laid down by the apex court in Rashish versus Neha. And by passing these kind of orders, again the courts again this court has to remand the matters, and it is giving unnecessary rise to unnecessary litigation. When the court is passing an order, there should be reason. It should contain some reasoning for granting such an order. Unfortunately, the courts are passing orders in a mechanical way without appreciating the evidence on record. And why an amount of rupees 8,000 is granted, there is no basis for that. In that view of the matter, the order impugned dated so and so is set aside. Matter is remanded back to the trial court, to the family court, fresh consideration. Accordingly, this court is passing the following order. The order dated so and so is set aside, and the matter is remanded to the family court, where the court shall consider the respective statements of assets and liabilities filed by both the parties and shall pass an order in accordance with law. Number 2, till pending consideration of that application, the court shall hear the matter. The petitioner shall pay an amount of rupees 9,000.
In D,
Interim order.
Because of the reason that in criminal is domestic violence, in the domestic violence act.
It is as he is already, he shall continue to pay 9,000 as ordered in the criminal, in the DVC case. And the court shall dispose of this IA number 3 within a period of 2 months from the date of receipt of the copy of the order.
The DV Act, for 3 persons, 3,000 each has been granted. Now the warrants are in the custody of the petitioner as per the order passed in the JNW. Okay, I am liable to pay 6,000.
if only 3,000 is given, Your Honor, it will be very difficult for the respondent.
All that will be taken care of by the court. Yes, next. Tell the court all that. This order, impugned order is passed, the blanket order is granted because you said you are paying 9,000 in that. That only you pay, that's what I said.
9,000 after that, yeah, for 3 persons have paid 9,000. And the JNW say,
When was it disposed of?
it is disposed of on 4/9/2024, my lordship. And thereafter, in the JNWC, the warrants are taken to the custody of the petitioner.
Did you bring it to the notice of this court?
Not on record, Your Honor.
I have first time I bring to the notice of this court that for 3 persons 9,000 is awarded, 3,000 each. Totally
That I understand. At the time of, when was impugned or interim order passed? That is in the month of January. That is the order in the domestic violence case. That, I mean the JNWC.
Thereafter, the JNWC, the order passed is under JNWC.
That's what I have. GNWC order is first. This interim order is second.
The JNWC order passed second.
When was it?
JNWC
That's
order
why you
wasn't
said it is
passed
in 2024.
voluntarily.
Just wait.
The JNWC order was passed on.
There's no order sheet.
22/4 is my order. This is the initial order.
Yes. Just leave it. Yes, next.
Cell number 20.
Huh? Oh, yes.
Directed to dispose as.
I said 2 weeks, 2 months.
Cell
Yes.
number 30. Cell number 30, Anandram K, petitioner K. Ravi Shankar.
Yes. Let him be. Let him. We can't help him. Yes.
I filed an application for alignment of the written statement and the counterclaim.
Mm.
Alignment was sought for regarding return of gold ornaments and jewelry. Matter was posted for further evidence of the defendant. That time the application was filed. And the court has rejected saying there is no due diligence on my part. I'm not seeking for any further evidence, Lord. I'm just seeking for one fair, Lord, in the
No, why? How can? How is it sufficient? No, another prayer is sought. For that prayer, there has to be an issue. There has to be an evidence.
Lord, I checked the origin thousand. So far, the issues are not fit. Lord, I'm told, Lord, the time of the judgment only they will take the points of consideration and then, Lord, the judgment will be.
How can it be? When the trial, the starting stage of the trial is framing of the issues.
But I checked the origin thousand, Lord.
When the trial commenced?
Lord, the trial commenced. In fact, what had happened, Lord, initially I had come before your lordship, Lord, seeking Lord appointment of a guardian. Your lordship and passed an order. Then there was a stage, Lord, though there was a stage, the trial had proceeded, Lord, PW1, the husband examined himself. Then, Lord, your lordship remanded the matter. Again, second round of litigation. Again, there was a stage, and then again it was remanded. And ultimately, my guardianship application was allowed on the ground that, Lord, the wife had some sort of issues. After that, immediately after that, I filed my return statement within 15 days. I filed once the guardianship application was allowed. My return statement was filed on 26/3/2025.
Then there has to be a counterclaim.
Yes, return statement and counterclaim I have filed together on 26/3/2025. On 5/6/2005, the PW1 was cross-examined. Till that the cross-examination was not over, he had examined himself and marked certain documents. On 5/6/2025, it was cross-examined them on various dates. One of the dates is 5/6/25. On that day, we learned para 31 of his cross-examination.
So what is the reason for filing the application belatedly?
Lord, the reason is not earlier for Indian notice that it was not sought. The reason that is given in the application.
No, entire course of action will change.
No, Lord, it is only Lord in para 31 of his cross-examination, he admits that whatever things are there with him, he is ready to return it to the.
He will give it. Then why should you have a prayer like this?
Without a prayer, not formal prayer, and ultimately my prayer without a prayer.
No, admitted facts. He has admitted it.
But there is no prayer. For technical ground, Lord, my belief will not be denied. That is the.
No, anyhow, I'm not able to understand this procedure that issues will be framed at the time of pronouncement of judgment.
That is not even I tried looking at the entire opportunity, I could not find where the issues are framed.
No, special CPC for them.
Exercise and visitation.
So, day after tomorrow, it is listed for arguments.
Where is it?
On Saturday, we have listed for
Where is it? Where is the impugned order?
impugned order. The impugned order is the election end.
Page number?
Page number 126. The operative portion, there are several orders found on that day. The relevant order is at page 129. Order on IA number 25.
Yes.
Page 129. Because the consideration would start at page 132.
What is the MC for? MC for?
Divorce.
What is your counterclaim?
My counterclaim, Lord, is also divorce on the ground of purity. And Lord,
Their ground is?
alimony.
Their ground is?
Their ground, Lord, is also on the ground of purity.
Hmm.
Lord, they, in fact, the Lordship would recall, they in their petition itself, Lord, alleged that I was not of sound mind and all that.
No, that is, then you sought for alimony of how much?
Lord, alimony of 1.5.
And in the pleadings,
Yes.
you stated about this gold articles that are with them.
Pleadings, unfortunately. Not there.
So without those pleadings, how can there be a prayer now?
Lord, he has admitted this evidence.
It's not that. You can't
I
say,
did not pleadings, not any amount of evidence.
no, not that. There is no pleading. Now you want a prayer. How can you have a prayer without any pleadings?
Because since he has admitted,
That can't be. At least I can understand you have already made your stand in the pleadings and a prayer is not sought. Now you want to seek the prayer. It's a different thing. You have not stated anything in your pleadings, in your written statement. Suddenly now you come up and say that this is what, how can that be? Your prayer should found somewhere in your pleadings that.
Yes. But what happened was somehow it had skipped them at that point in time. And then
Then where is that IA file, let us see?
Your IA is at connection L.
Page number?
When it was posted for further evidence of the defendant.
And unfortunately, in this amendment petition, you don't even ask for amendment of the pleadings by inserting that prayer in that paragraph along with the prayer. You just want a prayer.
The reason was because it was already in the stage of.
At least we can understand that if there are pleadings and a prayer, and now only prayer without pleadings. Yes, come.
Application is at page 118.
We can't help it now. Where is the impugned order? Page number 130?
Page 129. It starts at page 129.
Agreed with the order passed in. Agreed with that.
Formal prayer belongs to the lordships.
But you can't have it without a pleading. That's a whole
Take
problem.
my chances before the trial court because there is an admission in the evidence.
That's why you withdraw this. But I have to. We can't allow. We can't. How it can be? Now, when you want a prayer, you will add the prayer, the amended portion of the pleadings also, and you will ask for the amendment of the prayer. Without a pleading, you want a prayer, and the court will allow for some reason that the petitioner has stated something. If he has admitted something, take advantage of it without a prayer. Agreed with the order passed in I number 25. Dated 20. Agreed with the order passed in IA number 25. in MC number 577 of 2021, dated 29/8/2025, whereby the court had dismissed an application filed by the defendant and filed by the respondent wife, filed by the wife under Order 6 Rule 17 with cost of 2,000. So to partly allow, we will, that the cost of 2,000 only we can, that's the order your client will get. Is rejected with cost of rupees 2,000. The wife had filed, the husband has filed MC seeking divorce. In that, the wife had filed the written statement and also filed a counterclaim seeking the relief of seeking divorce on the ground of cruelty and also sought for alimony. When after the trial has commenced, the present application is filed seeking amendment of the pleadings, amendment of the prayer, where she wants to.
I'm sorry.
You said that you are busy in
Yes.
other court, you can't come.
I'm very sorry. Sorry.
Morning also, other matters also, you are not there.
But my colleague says.
Nobody was there.
I'm extremely sorry, ma'am. Kindly pardon.
Where is that application?
Yes,
Mr. Page number?
Application, page number 180.
Come. He has filed this application seeking to add a prayer directing the husband to return all the gold ornaments weighing 736 grams, silver plates, silver vessels, silver vermilion box, silver lamp, expensive dress materials, books which are in custody of the husband in his house. That came to be dismissed by order impugned. While dismissing the application, the court had observed that the court had observed that the respondent has failed to make out that in spite of due diligence, he could not seek amendment of the counterclaim before commencement of the trial. If the application is allowed at this stage, definitely it will be going to cause huge prejudice to the husband. Secondly, it is going to cause inordinate delay in the disposal of the case. The contention of the wife that she had noticed omission to seek relief to return valuable gold ornaments and silver articles after completion of cross-examination of RW1 is untenable and unbelievable. Hence, dismiss the petition. When counsel appearing for the husband submits that the husband has accepted that he has in his cross-examination he has stated that whatever are the ornaments that are with him, he is ready to give. When whatever the things that are with him belonging to the wife, he is ready to give. It is submitted that if there is no prayer from the side of the wife, it would be it would have a on a technical on this technical issue, it would have it would have an impact on the case of the wife. Hence, I have sought for this relief. By allowing this relief, no prejudice would be caused to either of the parties. No prejudice would be caused to the husband. And the court, without considering all these on technicalities, had dismissed the petition. Next para. When counsel appearing for the respondent submits that the court had rightly held that, in spite of that, that why this particular amendment is not sought before the trial is not explained by the wife, and the court has rightly dismissed the application that the wife has failed to prove that in spite of due diligence this could not be done at an earliest point of time. Next para.
It's previously amendment was sought to the prayer.
At that point of time also, my lord, this prayer is not sought.
Submitted that already once an amendment application
prayer.
is filed seeking amendment of the prayer, and that was allowed. And now this is the second round where the application, where again amendment of the prayer is sought. Next, for having got the consensus on either side, there is a material on record. After the amendment to Order 6 Rule 17 CPC, unless the burden lies on the party that in spite of due diligence, they could not keep the same at an earliest point of time, that is before commencement of the trial. In this case, there is no pleading with regard to these gold ornaments and other articles. The petitioner, by wants to amend the prayer. There should be some nexus between the prayer and the pleadings. And without pleading, there cannot be any prayer. In this this application seeking amendment, they have not sought for amendment of pleadings, but only the prayer. The court has rightly held that the wife had failed to prove that in spite of due diligence, this relief could not be sought at an earliest point of time. And that too in the light of the fact that already amendment of prayer is sought. In these circumstances, this court do not see any reason to interfere with the order impugned. However, in the facts and circumstances, the cost of rupees 2,000 that is imposed by the court, to that extent the order is set aside. Yes.
Number 31.
My lord, I am for the petitioner, my lord.
Which case? 30? Yes.
My lord, I am for the petitioner. I am for the petitioner, my lord. I have already submitted my side of the argument. And it is, my lord, a respondent has to make submission.
No representation on behalf of the respondent. List this matter
May I,
after review. Under the
may I
same
request, my lord, last time also.
Now the
My
court
lord, I
has
requested.
no time to pass order now. Yes,
Serial
next.
number 32.
If you had been physical before the court, at least court would have taken. Now no time for this. Yes, next 32.
Serial number 32.
Respondent present.
Fatima escape for petitioner.
Yes. Why you have not, when there was an order of,
Last date.
you don't come,
Ah.
party don't come, why?
A trial court case.
So according to you, you will not come to the High Court when there is an order, you will go to the trial court.
Next date present.
No next date, we'll hear. Yes. Yes.
Appellant absent.
Where appellant is absent?
Appellant absent. Your Honor.
Who is appellant?
High Court Mediation Center approach you.
Huh?
Last
not sure what he's saying.
alumni High Court Mediation Center refer. Family court absent.
Where is impugned order?
No. Next trial court absent. My
Please
lord.
come to the impugned order.
See Miss DB Act pending, my lordship. Trial court. MC case pending, lordship.
Page number.
71. Reasoning part. May I just read, Lord?
Yes.
There is no dispute regarding marriages. Petitioner and respondent. Petitioner and respondent are qualified persons. It is also undisputed fact. The respondent is MSc degree holder and our monthly expenses is mentioned as 35,000 per month. Just produce bank statements. There is only balance of 1,500 as of 19/2022. Petitioner in the affidavit of assets and liabilities shown his qualification as B computer science. His income is shown as 13,000 per month. Plus, this is not his income. It is only the interest that he derives. The petitioner filed IT returns. Year 18-19, his gross income is 2,47,259. The bank statement discloses that from 2018, balance is maintained at 50,000 and odd. In the year 2020, rupees 26 lakhs 10,408 was created to this account, and this was transferred to another. Look, this is where I produce the memo along with the bank statement. He received this sum from the previous listing and he has deposited. The petitioner is having sweeping transparent as on 7/20/2020. He had 78,80,890, which is wrong amount in his account. The bank statement discloses that as on 5/7/22, he was holding rupees 1,06,97,490.
What is the balance in his account?
Plus balance is, may I just
Maintenance pending, my lordship.
She can argue.
Family
Yes.
court.
Plus, may I just request your lordship to
You can tell the amount. What is the balance amount in his account as of now?
but here it is, in this, it is only cumulative total.
Family court balance amount pending.
Please wait. You will have your turn. Let her argue.
The cumulative total is the only thing that is shown here. May I just ascertain the balance? 26,03,504.
What is his income per month?
Look, right now he does not have a job. He lost it. He lost his job. He's been looking. He has applied several places because he's expecting higher salary and because of the age that is not meeting.
And he is without a salary, he is able to maintain that bank balance of 26,000, 26 lakhs.
So that was the amount that he received when he was thrown out of the company, the previous one. That is why he receives 13,000 per month as interest itself.
No, 13,000 per month. How, when this 26 lakhs will accumulate?
Plus, that's what it's 26 lakhs he received from the previous company.
By what? What is
All his works and everything. It was settled by the previous company.
no, a person who receives 13,000 per month, works would come to 26 lakhs.
Plus, this 26 lakhs was a deposit that he had made, FD deposit. Per month, 13,000, 13 into 12 would come to more.
So every month he is receiving his salary.
Just right now he does not have a job.
He is receiving 13,000 per month according to you.
13,000
Earlier
per
when
month.
he was having work. You say when he was thrown out of the company, his works will come to 26 lakhs.
26 lakhs odd. That is what he has deposited. And 13,000, of course, he expenses he has to withdraw. Whatever is his expenses, food and other things, he has to withdraw.
He
that
will,
month.
monthly his salary will come.
He is not employed right now.
Earlier, 13,000, his salary will come to his account.
Because when earlier salary was there, this 13,000 wasn't there.
What was the salary then?
Salary was 2 lakh odd.
That's what I'm asking.
Yes.
Earlier salary was 2 lakh and odd.
2 lakh odd.
From when he is doing this 13,000 salary job?
That is from 2020, he's been earning 13,000 as interest. Which is there even in my affidavit of assets and liabilities.
According to you, how much he can pay now?
Plus, she is also a double graduate.
No, my lordship. False information.
She herself has stated, MSc degree holder.
Respondent.
Plus, both of them tried living for 5 years. On the last occasion, since the
I'm
council-
asking how much he is ready to pay. Husband.
whatever the court feels right.
Court feels 20 is right.
Because 20,000 is, she's
That's
not
why I asked you,
entitled.
what is that your client is ready to pay?
But I think 10,000 would be a fair amount. I would say.
What is her income?
Income ink work na no Your Honor. False argument. Respondent present. Is allegation document.
Yes, this
Create
is what
document.
clarification. Yes, next.
Appellant present.
We will see.
Next date.
No, appellant,
I court mediations into
Yes,
reference.
next.
Serial number 34, 33 adjourned, 34. K. Ravi Shankar, for petitioner.
Yes,
I'm sorry, my lord, it's not here.
yes.
Let's say, application, interim application under section 24 came to be rejected by the trial court filed by the wife, against which I am before your lordships.
Hmm.
But the manner in which it has been rejected,
Let's see,
Yes,
actual order.
last my page 13. May I read from the beginning or paragraph number 9, my lord? 9 onwards is the consideration.
Read.
Yes. The parties are residing separately.
Para 8 may kindly be read.
ಆಯ್ತು, ಏತ್ ಅನ್ನೋದು. As per the facts of the case, the marital relationship between the parties to the proceedings is not in dispute. The respondent is a BBM graduate, and as per the affidavit of assets and liabilities is admitted, she is working as sale executive and Mr. So and so, December 2024, and earning Rs 12,000 per month. The parties are residing separately from so and so, 24/11/2018. After their marriage on 26/8/2018, they were not even led a marital life for 4 months. The respondent is not having any children out of the wedlock. After separation for all these years, the respondent has not claimed any maintenance from the petitioner. The petitioner has filed a memo and produced the copy of the medical certificate, evidence of the respondent in an earlier petition number so and so. The respondent earlier filed a MC number so and so against the petitioner husband under section 12(1)(a) of the Hindu Marriage Act, and the declaration of the nullity in her marriage. The said petition came to be dismissed as per judgment so and so. The argument of the petitioner in the present case and the prima facie facts that the case shows her 3 months from the date of marriage, the respondent wife had left the matrimonial home and deserted the petitioner for all these years. Therefore, the claim of the respondent for interim maintenance and litigation expenses is prima facie not bona fide.
Why the wife is not entitled for maintenance according to the court? I'm not able to understand.
No. This, my lord, so far as the income is concerned, my lord, the husband, my lord, is a poor agriculturist, my lord, he has no his own source of income. That has been pointed out, my lord, in the assets and liability. My lord, he admittedly, my lord, at the time of marriage, he was assisting his father in agriculture income, and he had no income. That was admitted in the
No, that is not forthcoming in the order.
no, in the earlier petition, my lord, which I have produced along with the memo.
No, not that. We are not, this is the order impugned. Court has to give reasons why the court is passing an order and why the court is holding that she is not entitled for interim maintenance. None of the reasons that are stated in this are grounds to dismiss the application.
No, assets and liabilities, my lord, are filed in the court, my lord.
Where is the discussion? Because you can't supplement something into the order which is not written.
But discussion is not there, my lord, here, my lord, but the court has looked into the facts, my lord, that barely within 3 months she has filed a case,
The
MC
court has
case.
probably gone into
Lord,
the
see-
under section 125. If the desertion is proved, your lordship may kindly see under section 125. If the wife is deserted, he is not entitled. She is not entitled for maintenance.
She is a divorced wife or
No. Same, because in earlier,
See,
yes, my lord. MC has been filed for on the ground of my lord, impotency. That was not proved. It is dismissed. Now he has filed a divorce petition in which I was arrayed as a party respondent. I filed an application under section 24. The parameters of considering the application under section 24 is different from that of the application filed under section 125. Last aware, my lord, under section 125, the parameters if the deserted wife is not entitled for maintenance, that judgment has been called out and my petition is dismissed. That is not impermissible under law.
No, my lord, so far as the reasons assigned, my lord, the court has not
they're only on that.
looked into the assets and liabilities, my lord.
He's only before this court questioning the order that is passed, the reasoning that are given.
That may be, my lord, the matter may be remanded back, my lord, court, my lord,
Please
for
come.
fresh consideration.
Agreed with the order passed 9 number 5 and MC number 502 of 2024, dated 25th June 2025, whereby the court had dismissed the application that's filed by the, this also copy. The application filed by the wife seeking interim maintenance. The husband is before this court. The wife is before this court. Land counsel appearing for the wife submits that. When the wife has sought for filed an IA under section 24 of the Hindu Marriage Act, the court, without considering the facts of the case and without giving any reasoning, had dismissed the petition, and the same needs to be set aside. Land counsel for the respondent submits that The court, looking at the statement of assets and liabilities and the financial status of the parties, had rightly dismissed the petition, and there are no grounds. There are no grounds. Next paragraph, the counsel on the said as a material monitor. When an application is filed by the filed before the court under section 24 of the Hindu Marriage Act seeking maintenance, court has to consider the application on the facts of it, and the court has to discuss why, has to give reasons why a party is entitled or a party is not entitled. Unfortunately, in this case, why the party is not entitled for maintenance, the order that is passed is without any reasoning, and on what basis this order is passed, this court is not able to understand. In that view of the matter, the order impugned dated so and so is set aside. The matter is remanded back to the family court for fresh consideration. Both the parties shall appear before within 2 months from the date of receipt of the copy of the order. The court shall dispose of the matter by considering the statement of assets and liabilities filed by both the parties accordingly allowed.
Public.
Yes, next.
List number 2. Come on.
Before the
List number
petition.
2.
Have you paid the up-to-date maintenance?
Yes, up-to-date maintenance is paid.
It is submitted that the maintenance amount is paid as per the order dated 29/1/2025. This is matter after vacation.
So
Yes,
far
next.
as education expenses will not,
All that, this is not your appeal, your petition, that's his petition. Yes, next.
Allah, is an ex parte order, it may be remanded.
this is
If it is there, it is an ex parte
expert
order.
order, my lord.
Yes. What was the interim order? How much was directed to pay?
It was directed to pay 8,000.
8,000. That you continue.
8,000 up to 12 years, my lord. After that, 10,000.
Continue to pay that. No, no, interim order I'm asking. Any interim-
8,000, 8,000.
That order you comply with. Please come. Agreed with the orders passed to criminal.
So it was not an interim order, it is a final order actually.
Yes. Agreed with interim order of this court, I'm saying.
Yes, this court is 8,000.
Agreed with the order passed to criminal miscellaneous number 283 of 2021 dated 30th October 2021, whereby the court had granted maintenance of an amount of rupees 8,000 to the child till he attains the age of 12 years, and after completion of 12 years, 10,000 till he attains the majority. The father is before this court, and counsel appearing the father submits that this is an ex parte order, and without giving an opportunity, this order has been passed. If an opportunity is given, he will file a statement of assets and liabilities, basing on that the court may pass the order. Then counsel appearing for the respondent submits that when an opportunity is given, he has failed to contest, the order impugned is passed, and there are no grounds to remand the matter. Next, for having heard so and so. When this matter came up for hearing, an interim order was passed whereby he was directed to pay 8,000 as maintenance, and accordingly, as per that, it is submitted by the respondent that he has been paying the amount as per the order passed by this court. Considering this as the order of this court is complied with, balancing the interest of both the parties, this court deems it appropriate to remand the matter. Accordingly, the court is passing the following order. The order dated so and so is set aside, and the matter is remanded to the family court. Till during the pendency of the criminal miscellaneous, the husband shall continue to pay 8,000. The father shall continue to pay 8,000. The court, he shall file his statement of assets. Both the parties shall file their statement of assets and liabilities within 2 months from the date of receipt of the copy of the.
It is not the wife, it is the children. Maternal grandmother is.
The father shall file his statement of assets and liabilities and liabilities within 2 months from the date of receipt of the copy of the order, and within 2 months from thereon, the court shall decide the application.
In addition, my lord, education expenses are ordered by the trial court.
Let once that is determined, the court will grant. Yes, next.
Serial number 2 urgent. Serial number 3 Venkat Reddy GK for petitioners.
I comply the order of this court. I am filing a memo affidavit along with the
producing certified copy of the order of the trial court.
On filing of affidavit by advocate for petitioner.
Now I am filing. I apply the certified copy of the order.
On filing of acknowledgement for having deposited 5,000 per month
Producing certified copy of the entire order of trial.
that you have already paid.
Already paid.
Interim order is there.
Interim order is there.
As per the order passed by this court, it is submitted that he has paid the amount. This is matter. Notice to the respondent. This is matter after.
I asked to the restoration.
This is matter after. We'll see after vacation. This is matter after vacation.
That notice may be ordered to serve the advocate who was on record before trial court.
Who is the advocate? EP is filed.
Already EP is filed.
The petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. List is matter after vacation. Yes.
Serial number 4. Ashok Kumar.
I am for the petitioner.
Yes.
Husband's petition, my lord,
Yes.
challenging the interim order wherein it has been directed to pay 15,000 to the respondent and 10,000 to the 10,000 to the child, my lord, respondent number 2.
25,000.
Page number 34.
And what is your salary?
My lord, as of now, I'm not working, my lord. It is the only for this reason, at 2017, I was being suspended from the duty. That is the reason, my lord.
Have you contested the matter?
I have contested.
Then did you tell the court that you are not earning?
It has been already told. The bank statement, everything has been produced.
Let's see the order.
Bank statement, everything has been produced, my lord. And it has been admitted by the respondent also that he was not working, and wherein petitioner was actually he was spending the amount in the.
Let's see the
Please.
reasoning.
Please.
Where did the court observe about your income? I don't find anywhere. Where is that? About your income?
Para 12, page number 10. As regards of the documents RW1, has produced the copy of the proceeding held before the police commissioner Mysore with respect to departmental inquiry held that as regards to R3 to R8 are the copies of the bank statement to prove that owns of the land property owned from her parents, that she is owning the property.
As regards the income of RW1, it is not in dispute that he had served in police department for a long time. Though he was said to be under suspension during the intervening period, but according to PW1, now he has been reinstated in service.
It has been stated, my lord, there is no documents has been produced. Even today, I have challenged that order. It is pending before this honorable court, my lord, for your writ appeal. Still, it has been not reinstated. It has been orally told. It has been
During
not.
suspension, what is the amount you are getting?
I was getting 28,000, my lord. And as of today, there is no income also. There is no arrears and no pension also is paying to me. So since from 2017, she has been deserted to
The order
me.
impugned had granted an amount of rupees 15,000 to the first petition, to the first respondent, and 10,000 to the second respondent till he attains majority. Altogether, an amount of rupees 25,000 is awarded, and counsel submits that he was working in police department because of the complaint made by the wife. He has been suspended, and the suspension is not revoked. But the court has recorded that now he is reinstated. That is without any basis, and it's a self-serving statement of the wife considering the same. They shall be stay of all further proceeding pursuant to the order dated so and so, on the condition that he shall continue to pay an amount of rupees 15,000.
Some reasonable amount. He is having a hand loan and he is leading his life because their allegation is, my lord.
They are having 28,000.
That was that time, lord. Now there is no any income for me.
Why you are not removed from service? You are still in suspension.
He is suspended. He is suspended due to the internal dispute in the department. Till now, he has been not reinstated. He is still contesting the matter before the appeal. These are
Pending suspension, you will not
illa
get.
sigalla Swami, kodalla.
Why?
They are not giving, until the matter is being getting settled, they are not taking the reinstate amount, and even the arrears also they are not paying. That is what my,
Pending inquiry, they will not give you
No,
any
no.
subsistence allowance.
as of till today, they are not paying.
Why you will not be?
I have been challenged, the very same order has been challenged before the Lordship. This honorable
It is
court.
submitted that he is not getting any amount.
And they are very much aware about it.
They shall be stay of all further proceedings. Pursuant to the order dated so and so. Yes, fine.
Notice to.
Notice, the emergent notice to the respondent.
Yes.
Yes, next.
Serial number 5,
I'm for the
Ashok Kumar Shetty K.
husband petition. What is the reason for the delay of 169 days?
I'm working in a garage and earning only 15,000 millard and I could not.
All those things will not do. When an application is filed under section 5, it should contain reasons. Mechanically, I will not condone the delay.
I have explained millard.
Please come to the IA.
I is at page number 43 millard.
40?
43 and my affidavit is at page number 45, 46.
Please wait.
Well, that is that IA is for a stay millard.
Nothing.
That is for stay. Only the IA first, you know.
You have argued on the merits of the matter. All averments on the merits of the matter. How wife is not entitled. How are you entitled to be heard before this court is what has to be stated in this petition. The petitioner.
I have filed separate IA for condemnation of delay also.
I am looking at that only. Where is that?
That is separate at page number, separately filed, my lord. Page number 3.
Please read that affidavit also.
The petitioner is advised to submit that he has got a good case on merits. The court below has failed to properly appreciate.
That is on the merits of the matter. Same affidavit for both cut and copy paste.
No, my lord, could not make, yes. Because I am working as a driver and earning meager amount. I am facing serious financial
Is it
and
a ground
domestic
for condoning
problems.
the delay?
And
I'll not condone the delay.
my lord, I could not afford to.
Where did you say?
Go to the, I have stayed. In page number 4, my lord, and the
How did
separate.
you come today? Now,
Separately.
all this, unless and until in all these matters, the warrant is issued or the wife files the EP, till such time the husband will not question the order passed in a criminal miscellaneous. We will stop that procedure. If he is aggrieved, he should come to the court immediately. At least you should state the reasons. Your affidavit is bereft of reasons.
Stated, my lord, I have stated.
That is not the reason to condone the delay.
Because of
either you file a
financial
better
and domestic
affidavit or I
problems,
will
I could
discuss
not.
it on the ground.
I'll file.
This is matter after vacation.
Cell number 6.
I'll file better IA, my lord.
Motion, my
Yes, list this matter after vacation. Council is permitted to file a better affidavit. The petition is permitted to file a better affidavit. Yes.
Cell number 6. Padma Bhushan, my lord, for petitioner.
This time on next time.
Huh?
Senior out of this another son on.
After vacation, no notice. Yes,
Cell number 7. Cell number 7,
Husband
Raju
petition,
CN.
my lord. Husband petition. The petitioner is aged about 65 years. The wife is, my lord, second wife. She also divorced, my lord. He is agriculturist. 15,000 has been awarded.
Hmm.
And she is also admitted, she has filed assets liability, my lord. She says that no property. But
I
in the
number 1025 is filed. What is the delay? Reason for the delay?
delay, my lord, she is suffering from age-old ailments, my lord. Hence, there is a delay, my lord. Page 33, I have stated.
I number 1025 is filed to condone the delay of 89 days in filing. Considering the age of the petitioner and for the reason stated, the delay is condoned. Oh, sorry. Notice to the respondents. Where is the IA? First day. What is the amount granted?
15,000, my lord. No children, my lord. She is second wife. She is got divorce from first husband, my lord. She is aged about 45 years. He is 65 years, my lord. From her first husband, my lord, she has taken.
Forget about the first husband. No, you are the husband.
Please, madam, I am agriculturist, madam.
Have you filed your statement of assets and liabilities?
No, my lord, I have not filed with
Why? You will not file statement of assets and liabilities. You will not come to the court immediately. So why should court come to your rescue? 7.5.
My lord, it's warrant issued, my lord. He is in hospital.
The petitioner shall pay an amount of, there shall be stay of all further proceedings on the condition that he shall pay an amount of 7,500 by 5th of every succeeding month, and also arrears at 7,500 within 8 weeks from the date of, within 12 weeks from the date of receipt of the copy of the order. Issue emergent notice to the respondent.
Yes.
On such deposit, the wife is entitled to withdraw. In all the matters, you write that. Yes.
Chair number 8, Prasanna VR, a petitioner.
We'll hear it after vacation.
Please.
9 after vacation.
Chair number 9.
10 also after vacation.
Yes, ma'am. Chair number 11, adjourned. Chair number 12.
11.
Notice 11 and notice is already ordered.
11, my lord. This one
11 will, somebody has made a mention in the morning saying that it is already informed.
not informed me, my lord.
Now it has become, that's why I don't
On the
adjourn the
previous date
matters.
also, my lord, they took an adjournment stating that they have a ceremony at home, my lord. Today, without informing me, they have taken an adjournment.
After vacation. Next.
Chair number 12.
Well, notice may be ordered. There is no interim relief.
Already served. Already respondent is served.
11. Which
Well,
one,
well,
sir?
well. Well, it has come up for admission. Notice. It is not served. Today it is for.
12 is served. Harish Pandari, that's not your case. Yes. After vacation.
My lord, 10, my lord, only 5,000 has been awarded. A date may be fixed, my lord.
It will come after vacation. 13.
Serial number 13.
Yes, 13.
Geeta, arrest. Serial number 13.
Yes, Geeta. After vacation, no representation. 14.
Number 14.
For petitioner, my lords. My lords, this is a case where the entire petition got disposed in a span of 30 days, my lord, without providing opportunity, my lord.
After
And,
vacation, 14. Yes, 15.
my lord, in the meantime, there may be a stay, my lord, because the execution
no
proceeding
stay,
has been
no
filed, my lord.
stay.
At least a date may be fixed, my lords.
After vacation, it will come.
I appear on behalf of the petitioner in serial number 15, my lord.
15.
Yes.
Samir.
My lord, the maintenance of 20,000 is ordered.
What is your income?
My income is 1,37,000.
Then what's the difficulty to give it to the wife notice?
Issue notice.
Next.
Serial number 5.
All these final hearing matters after vacation.
Serial after vacation. List number 3.
My lord, may I request serial number 19, my lord, the date to be fixed, my lord, 16th October.
Yes, we can't fix now. Let it come after vacation. 21, 22
Please.
also after vacation.
Yes, ma'am.
Please,
List
madam.
number, list number 3, serial number 1, G. Vijay Kumar.
May kindly refer the local, the other side I will inform.
Yes, both the bodies submitted the matter may refer to the Ropadara. Yes, places matters.
For orders, Geeta are awaiting.
Company appeal. Only pay and recovery order has to be passed. That has not been.
Yes. All are served.
All are served.
You that.
We had examined RTO. It's a case of no driving license, but the tribunal has disbelieved the evidence of RW2. That is RTO.
Why?
He has said that we have not issued any license. And the tribunal says have not proved, and there is a charge sheet that is filed against the driver of the offending vehicle for driving the vehicle for not holding driving license. And owner has very much represented and he has contested the matter. Still, the tribunal ought to have drawn adverse inference.
Let's see the file.
Yes, my lords.
No, the charge sheet is filed under the provisions of the.
Yes, my lords. Yes, my lords.
14.
Where do you get that? That
It
you
is
please
at
show.
page 18, my lords.
18. Yes.
I would read, my lords. Admittedly, vehicle involved in the accident is covered under the insurance with the respondent number 3. The evidence.
Waiting list. Yes.
The evidence of RW1 is the paragraph number 18, internal page 10 of the judgment. Page 22, my lords, at the bottom. Bottom, my lords. Admittedly, the vehicle involved in the accident is covered under the insurance with the respondent number 3, but the evidence of RW1 reveals that though they have issued notice for production of driving license, the respondent number 1 has not produced the same. Hence, now the question consideration is whether the respondent number 3 company has proved the fact of breach of policy conditions or not. As mentioned, Supra, in order to discharge the burden, there is a breach of policy condition. The respondent number 3 has examined the RW2, who is alleged to the supervisor of ARTO office Unsur, who has relied upon exhibit P6, the B register extract of the
Where do you
vehicle.
get the charge sheet and the provision?
The charge sheet, it is at exhibit two, my lords, exhibit P2.
No, where is the mention about this exhibit P2 in the order?
The tribunal has not mentioned it, my lords.
You have the TCR?
Yes, I have a charge sheet, my lords.
Take that, please. Take that.
Certified copy. The top, your lordship would find. 181 is there, my lords.
Two 338.
181 is there.
304A IPC. No, it will also be, it will be like section 3(1) read with 181.
At column 14, it is mentioned, my lords. I would
Column
read it out
number?
that. End column, my lords. I would read out that.
No, it is not there.
It is there, my lords.
Section 3(1) is not there.
No, but it is mentioned that vehicle is plied without a driving license in words, my lords. I would read.
Please from this. Where do you get that in column number?
17, my lords. I would show it to you.
Column number 17.
Column number 7, sir.
Notice ತಿಳ್ಕೊಳ್ಳಿ madam. I would read my notes. ದಿನಾಂಕ 10/9/2015 ರಾತ್ರಿ 7:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮೃತಪಟ್ಟು ಆರೋಪಿ ಸ್ವಾಮಿಗೌಡ ಅವರು ಸಹ ಬಂದು ಸೊಂಟಕ್ಕೆ ಸಾಮಾನ್ಯ ಬಲ ಸ್ವರೂಪದ ಗಾಯವಾಗಿದ್ದು ಹಾಗೂ ಆರೋಪಿಯವರು ಸ್ಟಾರ್ ಸಿಟಿ ಬೈಕ್ ಇದೆ, ಯಾವುದೇ ಕಂಪನಿಯ ವಿಮೆ ಇಲ್ಲದೆ ಇದ್ದರೂ ಸಹ ಆರೋಪಿ ಎರಡವರಿಗೆ ಮೋಟಾರ್ ಬೈಕ್ ಅನ್ನು ನೀಡುವುದರಿಂದ ತನಿಖೆಯನ್ನು ದುಡುಪಟ್ಟು ಮೇಲೆ ಕಾಲಂ ರೀತಿಯ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿ ಸಲ್ಲಿಸಿರುತ್ತದೆ.
ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ. ಯಾವುದೇ ಪಾಲಿಸಿ ಇಲ್ಲದೆ.
No, there is
it's not there.
Without policy.
It is said under section 181.
Otherwise, it would generally say under section 3(1).
We have examined RTO, my lords. RTO says
not about RTO. First of all, the main thing we have to know is from the, if it is there, the charge sheet would have been filed.
Charge sheet is filed under section 181, my lords.
Only 181.
181, yes, my lords. And owner has
181. Let's see the. Motor Vehicles Act. Section 3.
We have issued notice under order 12 rule 8 to the owner calling upon him to produce the driving license of the driver. He has not produced
So
it, my
first of all,
lords.
we have
Yes.
to, we have to get through
It's a
this.
part.
Then we'll go to the next one.
In contravention, it's section 3 and 4. Section 3 is not right. driving the motor vehicle in contravention with section 3 and 4 of the motor vehicles.
Please, please come. The present appeal is filed. Agreed to the award passed on embassy number 567 of 2016, dated 25th November 2019, whereby the court had held that the insurance company is liable to pay the compensation. The insurance company is before this court. When counsel appearing for the insurance company submits that when the driver of the offending vehicle is not having a driving license, as per the law laid down by the Apex Court in Sorensen's case, the principle of pay and recovery will apply. But the court has fixed the liability only on the insurance company. Next paragraph. It is submitted that the offences are under the as per section 181 of the 181 of the Motor Vehicles Act, which clearly shows that in contravention to section 3 and 4 of the Motor Vehicles Act, if any person drives a vehicle that entails criminal consequences, it is submitted that in spite of that, and then even the RDO was examined. In spite of that, the court had not considered the evidence and has applied the principle of pay and recover. Next, though notice is served on the respondent, there is no appearance on behalf of the respondents. That's what I'm saying. There is no representation. The no wakalat is filed on behalf of the respondent. Who is filed? R1 is served.
R1 is the rider.
R3 is served, no unrepresented. R1, A to D are represented by advocate, but there is no representation on their behalf. Having heard the learned counsel, the petitioner for his entire material on regard. Considering the fact that it is a case of the insurance company that the charge sheet is filed under section 181 of the Motor Vehicles Act, and they have examined the RDO. In spite of the same, the court had not considered the fact that there is no driving license. It is also stated that they have already they've called for they've issued a notice to the owner of the vehicle to place the driving license. In spite of the same, the tribunal has not applied the principle of pay and recover. Considering this court has perused the order as well as submission of the counsel, considering that the charge sheet is filed under 181, and also they are considering the evidence of the RDO. The driver of the offending vehicle is not having a valid driving license, the principle of pay and recover will apply, and the insurance company shall pay and recover the same from the owner of the vehicle. The amount in deposit shall be forthwith transferred. Yes,
amount in deposit may be transferred to the amount in deposit may be transferred to the.
I already said.
Much obliged. Grateful, my lords.
Yes.
Next one, pass over matter, serial number 23. Serial number 23.
What has happened?
For petitioner, my lord. Children have met with the mother. They have spoken, my lord.
Due to fear of the father, your lordship, they are not ready to talk with the mother. Earlier, your lordship, prior to that, your lordship, they were given a visitation rights for summer vacation. The children went with the mother and they were also staying with happily. But now, your lordship, for the June, July, August, September, second Saturday and fourth Saturday was granted in visitation rights, your lordship. That was not given by them. Even Dasara holiday was also given, your lordship, in the interim order. That was also not complied by them, your lordship.
My lord, after the order passed by this honorable court on 5/8/2025, my lord, on second Saturday of August and fourth Saturday of August and the second Saturday of this month, my lord, the petitioner had brought the children here, my lord. The respondent did not turn up.
What is the impugned order now, which is questioned before this court?
The interim custody order, my lord, passed by
Then
the
we
trial court.
will dismiss your application. We'll dismiss the
Lord,
petition, let consequences follow.
We had complained, my lord, and even we had brought the children, my lord. They
Further
did not.
thinking, what What is the father thinking, that he'll brainwash the children and?
No,
they
my
will-
lord, no such thing as, my lord, personally, I had taken the children and left with the mother, my lord, on two occasions today afternoon, my lord. One immediately during the lunch break and one around 3:15 p.m., my lord. And the father was not there, my lord. He was standing
Not
away
necessary
from
that
there.
he should be physically present.
He was far away, my lord, from there.
That's
From
what
where
I'm
the
saying.
children was there.
Not necessary that he should be physically present
My
there.
lord, and the children themselves, they came and told that they are,
Why they are not interested? There should be a reason for that.
they say, my lord, they cite some past incidents, my lord, wherein their father was assaulted by the relatives of the mother, and the mother
But
keeps
they're
complaining about the
remembering, and that
father.
is very bad for the father, and they don't want to see the mother.
My lord, it's not the conduct of the father, my lord, which has pushed the children to this, my
Tell
lord.
the father by tomorrow, if the father gives the custody and sends the children to the mother, and with the mother, if they come to the court tomorrow, then we'll consider this application that you have filed, or else I'll dismiss the writ petition. Tell the father. It's for him to take either ways he wants.
My lord, we will comply the order of the trial court, my lord, insofar as
Yes,
Dasra vacation is concerned, my lord. Even during summer vacation also, we had complied, my lord. It's not that we are not sent, my lord. And even the Dasra vacations also,
That's what I'm saying. Let the father send the children along with the mother today. Let her get them back tomorrow to the court. Then we will see. Or else I'll pass orders dismissing your writ petition.
my lord, may I,
Things won't go on like how the
No,
father
my lord.
wants. He has to look at the welfare of the children, and
I agree,
welfare
my
of the
lord.
children is not in meeting the mother and having these kind of grudge against the mother.
It's not dread, my lord, it's more of a,
Why? I'm making it very clear. Does this matter tomorrow? Yes.
my lord, may I make one submission, my lord. Maybe posted immediately after vacation, my lord, we'll comply the Dasra vacation. What is there, my
You're
lord?
not complying what the court said in the court premises. What
My
would
lord,
we
we
do?
complained, my lord, we send, my lord. If
Complying is not taking them and getting them back.
we did not get them back, my lord,
Is this matter tomorrow?
my lord, we were standing far away, my lord. Children themselves, they came, my lord.
List number.
Yes.
My lord,
Let the father instruct properly and send. Today, he has to send the child to the mother, and the mother should get them to the court tomorrow. And basing on that, I'll pass orders on your writ petition. This is the matter tomorrow, and don't write this order. Yes, next.
Serial
Please,
number 3, list number 3, serial number 3, Kavita HC.
Yes.
Lord, this is claimant's appeal seeking enhancement of
There is Mr.
compensation.
Shankar Reddy. Yes.
It's a case of injury, my lord. Fracture of pelvis. He's a 48-year-old agriculturist, my lord. As far as his income is concerned, it is as per the chart, my lord. 2018, 13,000 is taken, my lord. But only with regard to disability, my lord, I am contending that functional disability ought to have been taken because he's a agriculturist and a dairy farmer, my lord. And
How
it's
much is a limb disability according to the doctor?
18%, 18.6%.
18% to lower limb, lower limb.
Lower limb, 18%.
6% to the whole body.
According to you, 18, full 18 to be taken as a functional disability.
Millard, because 48-year-old and he's a pelvic fracture, Millard, rib fracture is also there. Rib fracture.
Then if we pass that order, it is very difficult in every case.
Millard,
I'm not inclined. If you
Millard,
want,
loss of amenities and other heads.
other things
Millard.
we will see.
Yes, Millard, other heads.
Where is the table?
Millard, table is at internal page 13, Millard, of the judgment.
Page
12 and 13 of the judgment.
1 minute.
He has suffered both pelvic fracture and 7th and 8th rib fracture.
How many fractures?
Only one.
Totally, my lord, then it would be 3 fractures because 2 ribs are fractured.
75,000 reasonably granted. Loss of income is for how many months?
3 months granted, my lord, but at least agriculturist 6 months, my lord. He wouldn't have.
7 days he was in patient.
He has to work
7
the
days.
lands, my lord.
We'll grant 1 more month. How much is taken? 13,000.
Yes, ma'am. Yes, 13,000.
52,000. Then
My lord, amenities, my lord,
medical expenses as it is.
as per the bills, my lord.
4,500. Then loss of future income as it is. Loss of amenities.
25. My lord, under that head, my lord may please consider. Because
Another 20,000 will about.
Yes.
Another 20,000, 45,000.
Yes.
And he was
How many days he was in hospital?
7 days.
7 days.
Then why 25,000 is awarded?
My
We
lord,
will not grant this 24 because that has to be reduced.
my lord,
We'll
they
grant like 25,000, another 10,000. 35 will grant. 25,000 as it is, we'll leave it. Three lakh 23,180. 2,90,180. I'll pass the order. Appeal is partly allowed, enhancing from 2,90,180 to 3,23,180. The enhanced amount will carry 6% interest. All other matters after vacation.
but in serial number 6, LCR may please be called, my lord.
Yes, 5.
6.
What is this?
That is furnishing of TF to R2 and
The needful shall be done by October 15.
5, my lord, I appear, my lord. 5, I am filing dispensation memo for R2 and R3, my lord.
Memo is filed, take that, seeking dispensation of notice to R2 and R3. Same is taken on record and notice so and so is dispensed with at the risk of appellant 6. MFA.
The lordships may called for LCR may be secured.
Admit post for final hearing, call for the TCR. Then 6-1.
LCR
6
may
is
please be called.
early hearing, return with office objections. 6 admit post for final hearing,
Delay may be condemned.
call for the TCR. There is a delay in 5 there is delay. It is by the
Please, my lord.
claimant.
KSRTC council is also there.
It's by the claimant.
Please.
I number 1 of 23 is filed in
My lord,
5.
my appeal is, it's owner's appeal, my lord.
5 Sarita Kulkarni.
Please, my lord, I appear
I
for.
number 5 of I number 1 of 23 is filed to condone the delay of 214 days in filing.
Okay.
In case the appeal is allowed,
Please,
the owner is liable to pay the interest for the said period.
Please, my lord, 65-35 apportionment is done. Contributory
No,
negligence.
I'm not going into that.
Please.
Yes, only for the delay. Yes,
Your lordships, may I request for a date to be fixed in this matter?
we will not fix any date. It will come after vacation. Then 7,
Serial number.
withdrawal of amount can be ordered. Huh? After vacation. Yes, like
7 after vacation. 8.
8,
8 it is in admission.
Just for a week's time to take steps.
a week's time for taking steps. 9.
Nine.
Income has to be considered and
Tomorrow, 9 tomorrow.
Tomorrow.
10.
Chair number 10. Vijay Kumar T.
seeking enhancement only.
Vijay Kumar.
You are seeking enhancement only. Tomorrow we have only half day. Yes, after vacation.
After chair number 11.
After vacation.
Chair number 12.
Yes, same order.
Chair number 13.
Huh?
No,
Date we can't fix because there are so many matters. Yes.
chair number 14. All final hearing matters.
Yes. All final hearing matters are adjourned to after vacation.
Serial number 20 day after tomorrow తీసుకుంటాం.
Day after tomorrow.
Last.
My lord, one submission. My lord, order dated 23/9/2025. There is a minute modification, my lord. The third edition principal judge family court Mysuru, madam, it has been stated as pending.
Look at what is he saying. Tomorrow take. Listed.
Serial number 20. ఏమన్నా disposal. గిరివలయ
ಮೈಸೂರು ಅಂತ ಆಗ್ಬಿಡುತ್ತೆ. ಮೇಡಮ್ ಇದು ಚಿಕ್ಕ ಕರೆಕ್ಷನ್ ಇದನ್ನ ಲಿಂಕ್ ತಗೊಂಡು ಹಾಕೋಬೇಕಾ ಇಲ್ಲ
ಏನಂತೆ
ಮೈಸೂರು ಅಂತ ಆಗ್ಬೇಕು.
ಇವ್ರೇನ್ ಮಾಡಿದಾರೆ?
ಬೆಂಗಳೂರು ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಹಾಕ್ಬೇಕಾ ಹಂಗೆ ಕರೆಕ್ಷನ್
ಅಂದ್ರೆ ಇದು ಆರ್ಡರ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಇದು ಯಾವ್ದೇ ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಡೋಣ ಬಿಡು.
ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀರಾ?
ಅಷ್ಟೇ. ಇನ್ನೇನ್ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೋದ್ರಲ್ಲ ಮೇಡಮ್.
to it what he is telling ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ.
ಏನಂತ ಹೇಳಿದ್ರು? ಲಿಸ್ಟ್ ಇಟ್ ಟುಮಾರೋ ಅಂದ್ರು.
See to it what he is telling ಅಂದ್ರು. ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಅವರು.
ಅಲ್ಲ ಇವ್ರೆ ಇವಾಗ ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಹೇಳಿ ಕೇಸ್ ಲಿಸ್ಟ್
ಕರೆಕ್ಷನ್
ಅದೇ ಇವ್ರೆ ಈ ಕೇಸ್ ಲಿಸ್ಟ್ ಮಾಡಿದಲ್ಲೇ ಮಾಡಕ್ಕಾಗುತ್ತಾ?